Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Massachusetts Appeals Court on this Monday, May 6, 2024. I'm Justice Joseph Ditkoff. To my right is Justice John Englander. To my left is Justice Paul Smyth, and we'll be the panel for all the cases today. Almost everyone here has experience, but let me just run through the basic rules. We have our clock. Each side will have 15 minutes. There's no rebuttal. When the clock gets down to 90 seconds, it'll turn yellow. When it gets down to 0, it'll turn red and start counting up. If it turns red, you can finish your sentence, but please don't say anything else unless you're answering questions from the panel, in which case, answer the questions for as long as it takes to do that. We have read the briefs. We have gone through the record. We are familiar with the cases. You can jump right into your argument. And with all that being said, I'll call the first case, Commonwealth versus Buchanan, 23P 1098. Counselor, whenever you're ready.
Thank you, Your Honors. Elaine Fraunhofer for, it's Corey Buchanan. I will begin by discussing the first issue I raised on the appeal, whether Mr. Buchanan was deprived of his Sixth Amendment right to effective assistance at the second probation violation hearing by his attorney's failure to raise the available legally supported defense of claim preclusion to dismiss the allegations in the May notice of probation violation that stemmed from the same April 3rd dispute that was the basis of the first notice of violation. In its opposition, the government recognizes that probation violation hearings are civil proceedings where, importantly, the res judicata doctrine of issue preclusion can be raised as made clear.
Does the government concede that it's a civil proceeding? I didn't catch that. I saw it in your brief. I didn't see it in the government's brief.
I thought they did. If I'm wrong, I think it's the...
I mean, where do you get that it's a civil proceeding from? Is there a case that says that?
Yes, in the cases that I cite in my brief, Your Honor, it says it's a civil proceeding. I think
which,
one of them is, give me one second.
Because it seems to me that...
Gagnon versus Carpelli. I thought it was Gagnon versus Carpelli.
That's not
say it's a civil proceeding?
That's not a probation violation case, right?
Yeah, Gagnon is, sure.
It is, I could be wrong, could be
I think, well, maybe that's parole, but one, I mean, yeah. Is Gagnon parole? Might be.
Let me just see. No, it wasn't Gagnon because I didn't cite that in my first brief.
There are two Supreme Court cases. One of them is probation and the other is not. One is Gagnon and the other is...
Anyway, it is a civil proceeding. I can't remember the case off the hand. I didn't actually think that was going to be a point of dispute.
But it's important because your brief proceeds from the assumption that the ordinary rules of res judicata apply in this context, but you don't have any case from Massachusetts that says that res judicata, claim preclusion principles, apply in the context of a probation revocation proceeding, do you?
Well, I do talk about Kimbrough-Tillery, which is cited in the...
That's a collateral estoppel case.
It's a res judicata.
It's a collateral estoppel case. Let's use the terms so that we know what we're talking about. So you're talking about claim preclusion, and that case is issue preclusion. Are there any cases that say that claim preclusion applies in Massachusetts?
No.
Okay.
But they do, but I guess I just want to say again, they do have cases like Kimbrough-Tillery where the Supreme Judicial Court said that res judicata doctrine of issue preclusion applies, and if res judicata doctrine of issue preclusion applies, there's really no reason to think claim preclusion wouldn't.
Well, there is a reason to think that because issue preclusion applies in normal criminal non-probation context, but claim preclusion doesn't. We go to double jeopardy to determine whether a new charge can be done based on the elements test. So if that's true, if it doesn't apply in a criminal case normally, why would it apply in a probation violation thing, which is still in the same criminal case?
Because it's a civil proceeding. I mean, it says in Kimbrough-Tillery, it said, well, we can't apply these criminal concepts because this is a civil proceeding. I'm sorry, yeah, because this is a civil proceeding. So here we apply the res judicata doctrine because it's a civil proceeding.
Have you looked at out-of-state cases on this issue?
I did look a little bit.
Number of them that say, in a probation context, we're not going to apply claim preclusion. There are a number that actually say we're not going to apply issue preclusion.
Right, but these are both res judicata doctrines, which our Supreme Judicial Court has said we will apply.
Well, I thought we just established you don't have a case on claim preclusion.
But they're two very related concepts, both stemming from res judicata, that our Supreme Judicial Court.
But they're not applied necessarily. I mean, you're in a different context, right? It's one that I have difficulty thinking of as an ordinary civil proceeding, which is why I asked the questions off the top. And, you know, as Judge Ditkoff points out, claim preclusion principles do not apply in the context of criminal cases, right?
Right.
And, you know, if you go and you look at, there are a number of cases that are maybe inconsistent with, I can't say that person's name, it's too many letters.
Buchanan, yeah.
But they're in, I mean, California, they won't apply the, you know, an issue preclusion doctrine. So maybe we can leave this issue and jump ahead to another issue, which is assuming that claim preclusion applies here in some way. Lead me through your analysis that leads to the conclusion that it applies to the facts of this case.
Right. So, I mean, I think it's important to say also, just with respect to that, because counsel for the prosecutor said, you know, they would have to have been omniscient to have known that this applied. I think Kim Tillery would lead you to the conclusion that you should at least raise that defense. And in this case, at the end of the first probation hearing, the judge specifically asked counsel, you know, is it maybe the case that the government has waived the ability to bring these other claims because they're all part of the same incident? That's how he described it.
So you kind of got to the answer to my question indirectly, but the words, they're all part of the same incident, is that your answer to my question? The reason claim preclusion applies here is because the allegations are, quote, all part of the same incident?
Yeah, and there's different ways that courts have described claim preclusion arising out of the same series of transactions, part of the same incident. I'm going to forget some of the other terminology, but
common nucleus of operative fact would be another way to think about it.
Common nucleus of operative facts, right? So the government, I'll just say, in, what was the case, the notice issue? Car Carriers versus Ford Motor Company, since all claims arose out of the same factual context, and since the appellants had sufficient knowledge to sue on one claim, they had sufficient knowledge to sue on the rest of their claims.
Okay, so apply that to the facts here.
Here, with minimal due diligence or practically no due diligence, the government would have known that Ms. Nutt had accused Mr. Buchanan of damaging the property in her home, damaging her car. They sent, the defense sent the...
Had she accused him of damaging the property in the car?
Yeah, the defense sent the prosecution a recording where she's on the phone with Mr. Buchanan's sister saying he is,
But that wasn't, you're now one step removed from what she actually complained about. You're saying the police should have figured out that there was also a malicious destruction of property of the car claim.
When they had when they were given her recording saying...
From a common nucleus of operative fact?
Oh, definitely. I mean, this all stemmed from him taking her car, and she was upset, and so they got into a verbal argument. I mean, they had many conversations with this alleged victim, and so how could they not have known that this was all about the car?
Why is it a common nucleus of operative fact? If the complaint that they brought is based on an alleged assault that took place in the house, right? And you say, and I understand this, at the slightly or somewhat around the same time, he also destroyed some property in the house. But the destruction of the car didn't occur at the same time, right?
Right. I believe it was part of the same operative, I'm going to forget the order of those words, nucleus of operative facts. It was the catalyst for the dispute that he took her car, and then they argued about that, and then he hit her car. So they would have, if they had done any due diligence, they would have known that he took her car, they would have known that he damaged her car, they would have known that he damaged her house, and obviously it's the Commonwealth of Massachusetts. They certainly have the ability to know whether he has only a learner's permit or not. So that is my answer that. But I do want to just sneak in this other reason why the attorney should have known to raise this defense. At the end of the first hearing, when the judge is saying, you know, maybe the government has waived this, they didn't, you know, this is all part of the same incident, and the prosecutor is saying, well, yeah, basically maybe we should, I'm going to forget the language, but he says something like, oh yeah, I had discussed this specifically with probation officer amending the complaint, so I agree that there's an issue there. And of course the issue is that the doctrine of claim preclusion would prevent a party from getting a second bite at the apple. This is a civil proceeding. They had to include all claims that were available to them. And
help me with the procedural context. So, because I confess when I read your brief, I was asking myself throughout, does she really have to win, she meaning you, have to win on the argument that it's ineffective assistance of counsel, or is there just a direct argument that this should have been dismissed on the basis of res judicata, if that's your argument? The procedural context is?
I would like to tell you that I should win either way, but I actually believe that defense counsel has to raise it. That they lose it if they don't, that because defense counsel didn't raise it, that defense was then lost.
The judge raised it and asked for briefing on it, right? Mm-hmm. The judge was well aware. So that's right, it's successive proceedings. So the judge was well aware in the second proceeding that he'd raised the question in the first proceeding.
Right, but she doesn't give him any legal authority to support it. And she doesn't even make an argument. She argues detrimental reliance, not waiver. I don't have a lot of time remaining, Your Honor, so I'm going to switch to the second issue that I raised on appeal, that counsel should have been prepared for the assault and battery on the correction officer charge. She admitted at the start of the hearings that she did not even know that the government was going to call the alleged victim, the correction officer, as a witness. So really the question is whether her complete lack of preparation deprived Mr. Buchanan of an otherwise available substantial defense. There are, of course, the reports that fellow correction officers prepared who witnessed the event that Officer Lerman alleged was an assault. These were reports that, again, trial counsel never obtained, and their accounts contradict Lerman's in pretty significant ways.
How do they contradict?
So, thought you'd ask. Directly contrary to Lerman's account, Officer Connors was in the bathroom when the alleged assault occurred. Officer Lerman claims that he was alone in the bathroom, that the assault occurs, and then Connors comes into the bathroom. So right there, he has some, his memory of the events shows were unclear, but there's a much more important part. Officer LaCroix also observed everything. He said he was standing by the room, outside the room, but could see everything that was happening. And what they say happened, according to their reports, they don't see Lerman and Buchanan's hands reaching into the toilet at all. In fact, both describe Officer Connors and Lerman immediately restraining Buchanan as he went to flush something in the toilet. So two other witnesses can see what's happening, Connors is in there in the bathroom with him, and neither of them see them reach their hands into Lerman and Buchanan reach their hands into the toilet. And that's where the alleged assault occurred. So this is not really that minor of a discrepancy. These are pretty significant difference in their accounts.
You just said that LaCroix says that he did not see them put their hands in the toilet, but that's not what LaCroix says. He just doesn't address that precise question in his report, right?
Yeah, I think if he would have, Lerman says they put their hands in it.
You said it as if there's a sentence here that says, I did not see their hands go in the toilet. It doesn't say that.
It doesn't say that, you're right. Okay. It doesn't say that their hands went in the toilet.
I witnessed
and that's where the assault occurred.
Officer Lerman go hands-on with said detainee in order to prevent him from flushing something down the toilet. Why isn't that entirely consistent with what the other statements say?
It's not consistent because what they're observing is that Buchanan goes to flush something, and Connors and Lerman grab Buchanan to stop him from flushing. What Lerman says is the assault is him throwing something in the toilet, and then the two of them reaching their hands into the toilet. And since Connors is there, right there with them, and doesn't see that and doesn't report that, the thing that was the assault, that's a pretty significant discrepancy there. Also, Lerman says Connors wasn't even in the room. Connors says he was in the room.
Did you try to interview Connors or LaCroix?
I did not, because I was relying, Your Honor, on the fact that what trial counsel failed to do, I mean, this is a probation violation hearing where the rules of evidence are somewhat more lax. First of all, you could have just introduced these reports, and of course, you could also have cross-examined Lerman about them. Lerman's account was, not perfectly lockstep. I think this has happened in this order. I'd have to look at my report. Again, there's contradictions, and so just by virtue of cross-examining Lerman at the probation violation hearing, saying, well, Officer Connors says he was in the room. Officer Connors didn't see either of you reach your hands into the toilet bowl. Neither did Officer LaCroix, who could see everything that was happening. I think having that information would have, as the cases that I cite, Commonwealth versus Tavares and Commonwealth versus Pope, that I cite in my brief, evidence is exculpatory if it corroborates the defendant's account, calls into question a material, although not indispensable element of the prosecution's version, or calls into question the credibility of a key witness. Here, Lerman was their only witness, and where that evidence was not particularly overwhelming, this kind of exculpatory evidence would be particularly impactful. And here, we also had the combined impact of counsel's failure to get those reports and failure to provide the judge with the standard of proof at the jail where Mr. Buchanan was found not guilty of this assault and battery. The same low level of proof, he was found not guilty at the jail. And the Commonwealth doesn't address this did not address this in their opposition, and the judge said he was relying, for the reason stated in the Commonwealth's opposition, was the reason he denied the motion for new hearing. So it's clear that he didn't address the cumulative impact. He had said he was specifically...
I think you went into a new sentence there.
Oh, yes, I did.
I have one final question. Is there any chance you know what happened at last week's probation violation hearing?
I do not. Thank you.
Thank you, Counselor. I assume I will hear from the Commonwealth now whenever you're ready.
The Commonwealth does know. Good morning. Hallie Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. I don't know with any level of specificity. I know that the defendant has picked up some pretty serious charges out of Norfolk. It's a 16-count indictment, starting with home invasion, armed assault in a dwelling, ABDW, armed robbery, and it goes on from there. There was a hearing a week ago today at which a Norfolk ADA stood up for the Commonwealth. It apparently has been continued until early June. The court's going to hear evidence. But if there's a violation found there, I think that moots this appeal, because the original probation would have still been ongoing.
Yeah, but it might change whether the defendant wants it vacated. So you don't know what happened in this violation hearing in Middlesex last week?
There was no finding.
No finding.
As of yet. The court wants, or someone is going to put on evidence, and that's all I know.
Hasn't happened yet.
Hasn't happened yet.
Right.
Won't happen for another month.
Don't understand why.
I'm happy to update the court.
Why would it moot this appeal?
Sorry?
How would this appeal be mooted?
Because the original probation was to go through the end of this year. So if this finding had been vacated or there had not been a violation, there's a violation now. So he'd be in he's.
Well,
Doesn't,
we don't need to figure out whether something that hasn't happened would moot the appeal. If it does happen, we'll certainly ask for guidance before we do anything.
I found out about this last night, so I don't have authority for that.
If it does come up, we won't do anything about mootness without asking the parties for their views.
Thank you, Your Honor. If I could sort of start from the end and work backwards, unless the court really wants to hear us about
I think you should talk about myself. I don't know about my colleagues, but I'd like to hear your response on res judicata. I mean, your opponent says, civil case, we should apply ordinary rules of res judicata, and under ordinary rules of res judicata, you guys are out because you did successive prosecutions from the same set of facts.
I disagree with that, and here's why. Although there are cases that say probation violation is a civil proceeding, and it's cited on page 30 of the defendant's brief. The case quoted is Commonwealth v. Petit Homme, 482 Mass 775, that says civil proceeding. But I think it's not a normal civil proceeding in the same way it's not a normal criminal proceeding. I think to insist on its being civil with all the, insistence on civil practice doctrines and civil procedure rules is inconsistent with the way that our courts have always treated probation proceedings as being less formal and more flexible than normal criminal proceedings. It seems
maybe
odd.
that's right. But where does that lead you with respect to the... So my memory of Gagnon and Scarpelli is that the court says, look, the Sixth Amendment rights don't apply here, but Fifth Amendment rights do, and they include some pretty serious rights with respect to an accused because his liberty's at stake or her liberty's at stake. So I'm sensitive and to the notion that it's not your ordinary civil case, but where does that lead you with respect to the application of preclusion rules?
I think it can all be dealt with by looking to the framework that this court and the SJC have used for analyzing surrender proceedings, which is with a more sort of generalized concern with due process. And it has, certain very specific things have been spelled out as included in those due process rights. Written notice, findings, if the judge relies entirely on
Okay, I agree with all
hearsay, so
that.
on.
Where does that lead you, though? I mean, I don't think this is a due process argument. This is an argument about sort of rational practice with respect to successive attempts to bring claims, right? Which is what res judicata and collateral estoppel are all about.
Sure. I don't think I disagree with that. But I also
But if you don't disagree with it, isn't she at least partially right?
No, and here's why. Because the argument that counsel made in asking, in between the two hearings, in asking for the surrender to be dismissed and the defendant to be released, I forget exactly how the motion was captioned, was the Commonwealth has had its shot. It doesn't get a second one. Defendant testified, there's also stuff about detrimental reliance. No serious question, I think, that the defendant's testimony was somehow not voluntary, but that he thought there was some implied promise that no one would proceed against him based on anything he said at the first surrender hearing. And the argument in substance was the Commonwealth doesn't get a second shot at this.
Okay.
That's what claim preclusion is, and I think in the context
but that's an argument that it was never waived, and so the judge erred.
No, I think the argument was that it was waived. That any further
I thought you were
claims.
just telling us that they essentially made the argument they don't get a second shot. That's
That
a claim
is what I think that is.
That's a claim preclusion argument. So
And
was
that's-
it wrong or was it right?
I think it's the only part of that gets any traction in this case is that the destruction of property inside the house is something the Commonwealth knew about. It was in the police reports. It was in the officer's testimony that he observed destruction of the house. The victim had said, he's destroyed my house. It's hard for me to see how you get a second, when the judge has said, I don't see a violation based on what I heard, based on what I've seen in these reports. I don't see how you get a second violation based on the defendant's. But that, again, that to my mind is based on a more sort of generalized and flexible conception of due process and basic fairness, where the Commonwealth had no reason to know that there had been any.
Now we kind of have a problem, because you just said that one of the bases for this violation was invalid, the destruction of the property in the house.
And destruction of the car was,
Well,
I think, entirely valid.
I understand there's other valid ones, but are you conceding we at least need to remand it to strike that one and reconsider whether this is the right resolution?
The court could do that. I'm not conceding that entirely. I admit it makes me a little uncomfortable.
What is the law on that? If there were 4 bases here, roughly, for violating him, and one of them turns out to be invalid, does it have to go back?
I don't think it has to. There's a footnote in my brief, I think, that addresses this. Footnote 4, Durling tells us that any conduct that violates the conditions of probation may be a basis for revocation.
Right, but the judge imposes a sentence at the end of this, right?
You could send it back and say, we think this should not have been a basis for violation, and so we instruct you to consider only the other bases.
My question is that required of us as an appellate court where one of the 4 bases turns out to be invalid? And this is all hypothetical.
I have seen no authority on that. Strangely, I don't know of a case that directly addresses that. I do know that, as long as we have something left, and this brings me to the second part of the argument, which is that there's been no showing that any lapses on counsel's part as to the basis, the assault and battery on a corrections officer, deprived the defendant of anything substantial. The reports in question are not so contradictory to what Officer Lerman put in his report or to what he testified to, as to by themselves cast doubt on the rightness of that finding.
You'd think that seeing a prisoner assault a correctional officer would be the kind of thing you'd definitely put in a report, and so we got 2 people who didn't see it and 1 person who saw it. Why wouldn't that be a substantial defense?
I think if this were an assault on a corrections officer where he, hauled off and took a swing at the officer, you would have a problem with that. But the character of the assault here, which is literally just pushing his hand away as their hands are in the toilet, I don't think that that's so dramatic or so obvious that one would necessarily expect it to be in the report, particularly for the second officer, LaCroix, who was not even in the room when it happened. And there's nothing to show that he had a clear view into the toilet and the 2 hands. Both of the other officers put in their reports that the defendant was highly agitated, violent, needed to be restrained, was shouting, "I want to bang this out now." One of them, and I can't remember, I think it's Connor, says he was actively resisting. It's not, and nobody says, "I did not see him touch the..."
And was it charged?
It wasn't charged.
Okay. I think that's the end of the answer.
I think that's the end of the answer. It wasn't charged, and I'm not sure by itself it would constitute an assault if it's just purely verbal. Could be I don't think it's even a threat, actually. But that's not been
To put a fine point on what you said earlier, in order for a reversal to occur here, your opponent would have to be right on all 4, if you will.
Yes.
There are 4 different components, right? There's malicious destruction in the house, there's malicious destruction of the car, there's the driving without a license, and then there's the assault and battery on the corrections officer.
Yes.
You have to be right on all of them, otherwise it would at least have to go back.
I think
would be your
at
position.
most it would have to go back to reconsider the disposition. But yes, I think that's correct. Just briefly, the fact that he was found not responsible, not guilty, whatever the finding was in the correction system, is of no moment. It wasn't simply the standard of review that was noted by the judge. It was also, he didn't know what the procedure was, whether there was evidence taken, whether the authorities in the prison heard testimony, and there was simply nothing about that. And there's been nothing to suggest that was deserved any more weight than the judge gave it here. So if there are no further questions, I'll rely on my brief and ask the court to affirm.
All right.
Thank you.
Thank you both. Very interesting case. We'll call the second case, 23P 932. We'll see whether I can get both defendants' names wrong. Commonwealth versus Flavel. 0 for 2. Whenever you're ready, Counselor. Oh, no, I'm sorry. Before you go, I just want to remind everyone that the victim's name should not be mentioned in this case. The name is impounded of the victim. Sorry.
All right, good morning, Your Honors. May it please the Court, Andrew Power for Defendant David Flavel. This is a claim under Lafler v. Cooper, and I'd like to begin by making 3 points. First of all, the facts of the case alone were insufficient to raise an insanity defense without an expert, and trial counsel did not have an expert. Second, trial counsel announced on day one that an insanity defense would be presented at trial and supported by an expert, Dr. Joss, who would testify about PTSD and depression. And third, there is a reasonable probability that a reasonable person in my client's position would have chosen to plead guilty had he been properly advised that an insanity defense was not viable, Dr. Joss was not testifying, and he faced overwhelming evidence of guilt from the Commonwealth.
Did he actually say Dr. Joss would be supporting that to the jury? I don't think he did. All he said to the jury was something along the lines of diminished capacity, it's an insanity defense. That's all he said, right?
That's what he said to the jury, but the time frame we're looking at is before trial, when the defendant was still considering, when a offer from the Commonwealth was still on the table.
It seems to be, in the briefs, it seems to be conceded that after the colloquy with the judge, at which he says, I don't have an expert, can you give us a reduced offer? He then meets with his client for an extended period of time. They take a continuance.
They take a continuance. It's not clear whether he met with his client or for how long they met. The affidavits state from counsel that Mr. Flavel did not accept any offer from the judge or from the Commonwealth. Mr. Flavel said he was not aware of the judge's offer, but he did not accept the Commonwealth's offer.
What are we to infer from the fact that the judge says I would give him 15 to 18, and the attorney says, it won't take long, I'll talk to him? What are we to infer from that?
I don't think there's a need for an inference because the record is clear. The attorney came back and asked for a continuance, so that offer had not been accepted. We acknowledge
right, but
that.
I thought you were arguing that your client didn't know that he'd been offered 15 to 18 and didn't know that there was a problem with whether there was an expert to support an insanity defense, both of which were reported to the judge, after which there was a break at which the lawyer spoke to his client. At some place in the briefs it says for 2 hours. Is that accurate? Because I couldn't pick that up from the transcript.
It's not clear. It wasn't in my brief. There was about a 2-hour break. The defendant, my client, was not present in court at the beginning when the break was taken. It's not clear when he was brought in, when counsel had a chance to speak with him. Because of the time delay, there's not a lot of memory there and a lot to work with. But I want to be clear. This is a Lafler claim.
I'm sorry. Go ahead then.
This is a Lafler claim, and what we're discussing is the choice my client made not to accept those plea offers from the judge and from the Commonwealth. And he did that, as he says, on the basis of having an insanity defense. His lawyer presented to him an insanity defense, a choice. You can go to trial. I will present an insanity defense to the jury. We will bring in an expert, Dr. Joss, who's been meeting with you, and he will testify that you have PTSD, depression, and there will be a basis for a mental disease or defect argument
So
on
is your,
Dr. Joss's
is your argument dependent on us to believe that Attorney Madden did not tell your client that Joss wasn't helpful when he made the decision to reject the 15 to 18?
It's dependent on what Attorney Madden stated in open court when he stated at page, I believe, 8 or 9 of transcript volume 1, I will go to trial on an insanity defense. I will present an insanity defense, and I will call Dr. Joss. So that was the last thing my client heard about it. And counsel said, regardless of what they said privately, counsel said very publicly and on the record that he was going to call Dr. Joss. Dr. Joss was going to testify about depression and PTSD, and that was going to support an insanity defense. And based on counsel's affidavit, counsel's own words and Dr. Joss's affidavit, Dr. Joss wasn't prepared to testify to any of that. Dr. Joss...
The statement, I will call Dr. Joss, that occurred after this break and after your client had rejected 15 to 18 years.
It's
assuming that he knew about it. Assuming he knew about it.
That he knew about it. So counsel comes back and asks for a continuance. The first thing he does is he asks for a continuance. So let's assume that counsel doesn't want to go to trial and counsel's representing the client. The client does not want to go to trial. The client wants 60 days. We need more time because the case is not ready yet.
There's no ineffective assistance to counsel in asking for a continuance at that point, right?
No, there is not. The ineffective assistance comes in after the continuance is denied. At that point, counsel had a duty to speak to the client and say, an insanity defense is not viable. You are facing overwhelming evidence. A guilty verdict is assured.
Why do we assume that he didn't say it before? Simply based on your client's affidavit? That does not discuss in any depth what actually was said during that conference, right?
Because counsel's own affidavit states that he thought an insanity defense was viable based solely on the facts of the case. He thought he could present an insanity defense based on Mr. Flavel's actions.
Was that ineffective assistance to counsel?
Yes, that was. That assumption was based on the case law. There is no case that says that simply passively or calmly attacking someone violently and attempting to rape them.
But there are cases that say he doesn't have to have an expert to get to a jury with an insanity defense.
There are cases like that, but there is no case that applies here. And those cases also are very vague. I had difficulty finding a fact pattern actually in those cases where what kind of case can be submitted to a jury for an insanity with an insanity instruction, gets an insanity instruction solely on the facts. They're very few and far between. I found that quote repeated in several cases, but I didn't actually see it applied. And it was certainly not applied in this context.
The judge basically says, look, I believe that and I can't remember how the judge says it, but it's along the lines of there was a break taken, and Madden had a conversation with his client, and then Madden came back and asked for a continuance, which was denied.
Correct.
Ineffective assistance, if those are the facts?
Ineffective, as I said, ineffective assistance for proceeding on an insanity defense at that time, promising...
What other defense did he have?
He didn't have another viable defense. So counsel should have told him that at that point, and counsel should have understood. Counsel thought he had a viable defense on the facts alone. He thought he could maybe rustle up another witness, witnesses who he hadn't spoken to.
But he wasn't allowed the time to do that.
He had months to talk to Dr. Udy and the other doctor, Dr. Thomas. He never contacted them. And let's also look at the timeline. Dr. Joss' trial, the first day of trial is April 21st. Dr. Joss tells counsel on April 15th, I think there are problems with this case. At that point, that's a red flag. Counsel should either reschedule the trial date or counsel the client that we're having problems with an insanity defense. He's on notice at that point. Dr. Joss interviews Mr. Flavel for the second time on April 18th. Trial begins on is scheduled for the 20th and begins on the 21st. Counsel lets that go. Counsel really doesn't speak to Dr. Joss in depth until April 20th and 21st, the first day of trial. Dr. Joss doesn't produce a report until April, I believe, 29th, the day the verdict is returned. I mean, running a witness that way is ineffective as well. Counsel had plenty of time to work with Dr. Joss to schedule the trial so as to be aware of what Dr. Joss was going to say and to understand whether an insanity defense would be viable in time for trial, and perhaps to come up with another defense or to counsel a client, look.
There are just so many gaps in it, right? Because we don't know what was said by Joss to the lawyer on April 15th. We don't know whether it was reasonable for the lawyer to think, I can go forward with a diminished capacity defense at that point, based on what I've been told. The second interview had not even occurred yet. The second interview doesn't occur until April 18th. They don't talk for 2 days. I don't know if it's a weekend or not. Do you know when the trial started? Did it start on a Monday?
I believe it started on a Tuesday, but I'm not sure.
Or they talk on the Monday?
Day 3 was
The interview took place
Might
on
have
a
been
Saturday.
Might have been Patriots Day that week.
Yeah, the interview took place over the weekend, I believe, yeah.
See, okay.
I think we're getting away from the main point, which is that counsel...
Okay. Let's hear the main point.
Well, no, Your Honor, I don't want to step on your...
You didn't interrupt me at all, counsel. You're doing great.
Okay.
What do you think is
So-
the main point?
The main point is that an insanity defense was not viable. The lawyer advised his client that it was and proceeded to trial on an insanity defense. Under Lafler Prong 1, that's ineffective assistance of counsel. And then let me address Lafler Prong 2, because I think it's also important to emphasize that the analysis of whether Mr. Flavel would have gone to trial is an objective one. And the motion judge made a mistake by applying a subjective analysis to Mr. Flavel's affidavit. Mr. Flavel submitted an affidavit saying, if I had known that Attorney Madden was completely unprepared to present his promised insanity defense at trial, if I would have accepted the plea and sentencing, I would have accepted the plea and sentencing offer that was on the table. Now that statement is required under Hill and Clark, but then the judge is not supposed to evaluate that statement subjectively and simply discredit, simply say, as she did, well, I don't believe that. I think he would have gone to trial anyway. I don't think he was interested in...
So what if the facts, uncontested facts, are the defendant says, I will not accept any plea under any circumstances, period. Would we still have to reverse it on ineffectiveness if we think a rational defendant would have accepted the plea?
Yes, because the test is, he says in his affidavit that he would have accepted the plea had he been properly advised. The question then is, under an objective standard, and I'm quoting from Lavrenenko here at page 55, is there a reasonable probability that a reasonable person in the circumstances of the defendant would have chosen to go to trial? That's the question objectively, and Judge Gantz explains at note 16, a judge cannot evaluate whether the defendant is telling the truth about a decision the defendant never made. So that's why. You can't look at it subjectively because he's talking hypothetically, basically, about a decision he didn't make, and the judge can't discredit that hypothetical statement. The judge is only supposed to look objectively whether a rational defendant would have also chosen to plead guilty in the same circumstances. And again, the standard, I just want to mention, is reasonable probability, which under Strickland and Marino is less than more than likely. So it's less than 50%. So the standard is not that high. You're looking at a reasonable probability that a rational defendant would have pled guilty. And I think the evidence shows that a rational defendant in these circumstances would have pled guilty, knowing that the Commonwealth's evidence was overwhelming, that they were facing a potential life sentence, 20 to life, and that they really didn't have any other options. I mean, of course, a defendant can insist on going to trial. And
How do we know he didn't? How do we know on these facts that he did not insist on going to trial?
well, if he insisted on going to trial, then the appropriate thing for counsel to do would not be to present the insanity defense, which was DOA. It would have been to go forward, challenge the witnesses, try to raise reasonable doubt, cross-examine aggressively, which he
I thought you said
precluded by admitting...
I thought you said there was no defense here. I thought you said there was no defense here.
I'm just saying, in the circumstances generally, if a client says, I don't want to plead, I want to go forward, and the case is hopeless, there is no defense, the lawyer can still try to raise reasonable doubt by raising credibility problems with the witnesses, which he didn't do here, because by presenting an insanity defense, he conceded that his client did it. The first thing he said was, I concede he did the act. He told that to the judge. And that's part of the insanity defense, of course.
All right, thank you very much. We'll hear from the Commonwealth.
Good morning, Your Honor. Sarah Lewis on behalf of the Commonwealth. We are asking this court to affirm the motion judge's decision denying the defendant's motion for new trial for two primary reasons. First, the motion judge correctly found that the trial judge had not abused his discretion in denying the defendant's motion to continue. And second, the defendant failed to meet his burden to show that counsel was ineffective in either handling the plea offers in this case or proceeding to trial on a defense of lack of criminal responsibility without an expert. I think that context here is incredibly important. Trial counsel faced the following situation: a strong case against his client, a doctor who, on the day of trial, he learned from would not testify in support of his lack of criminal responsibility defense, a client who, according to counsel's affidavit, rejected two plea offers, one from the Commonwealth and one from the plea judge that was more favorable. And he did so in favor of taking his chances at trial, as the motion judge recognized. And in this context, counsel was certainly not ineffective in the way he proceeded. I would quote from...
Look, stop there, though, because that's the nub of the problem. I mean, even assuming everything that you've said is accurate, and it seems to be what the judge found below, your opponent says you can't go to trial with the insanity defense under those circumstances. You've got no expert. You're now conceding that he did it, so you have no opportunity to try to introduce doubt in some way. And you should have known, as a lawyer of average competence, that your insanity defense was not going to go to the jury. You didn't have it. What do you say to that?
I think I would quote from Supreme Judicial Court's opinion in Velez 487 Mass 533, which said, quote, based on a review of the evidence, it's clear that trial counsel did not have particularly good cards in his hand. And the hand he was dealt here was a client who rejected two plea offers, one of which his attorney specifically went to the judge to ask for and said, Mr. Flavel is asking for 15 to 18 years. Yes, it was outside the presence of the defendant, but he specifically said, this is what my client's asking. Will you agree to it? In the face of that, the judge agrees. They go off the record. I think it is a fair inference from the record that the defendant rejected that plea and insisted they go to trial. And without the expert, I think it was a strategic decision that was not manifestly unreasonable for this attorney to move forward with what he had, which was to cross-examine these witnesses on the vacant look of the defendant, the calm and steady demeanor he had when he was caught red-handed in this bathroom, and to put forth to the jury to assess his mental condition, where the highest charge of which he was charged with was a specific intent crime. So this attorney uses his best effort to challenge the element of intent based on that alleged mental defect, even though he didn't have an expert. And I would just, as I know that the court will do, look at the entire record. This attorney didn't give up on the day of openings when he didn't have Dr. Joss. He continued to try to talk to additional doctors who could at least testify to the defendant's state of mind. The problem there was the state of mind was at the time of his competency evaluation as opposed to the time of the crime, and also it was inadmissible on hearsay grounds. It was discussed clearly on the record. But he's trying to shore up this defense. And I think it's reasonable from the record that this client, it's his choice to pursue a criminal responsibility defense.
Counselor, it seems to me that this case really turns on what Attorney Madden said to the defendant after the 15 to 18 offer was made by the judge. Surely he said there's a 15 to 18 offer. Surely he said Dr. Joss isn't very helpful. But did he tell him, I think still that we got a decent one, or it's going to be a 1 in 100 chance? And neither Attorney Madden or the defendant's affidavits really tell us what was said there. And so what I'm trying to figure out is, when we're missing that information, is that your problem, the defendant's problem, or is that an evidentiary hearing?
It's I guess, colloquially, a defendant's problem. The defendant...
I suspected you would say that, but I'd like to know why.
It's a defendant's burden to raise a substantial issue warranting an evidentiary hearing necessitating an evidentiary hearing or warranting a new trial. The defendant did not raise that substantial issue here, and by silence in the defendant's...
Why does he not raise a substantial issue here by saying, I believed, based on what the attorney said to me, that he could present an insanity defense?
I think because you look at that contention in an affidavit or that averment, and then also the record. And the record after the attorney goes off the record, says, let me talk to my client, and they come back on the record, Attorney Madden doesn't address the plea, as your honors are aware, and asks for the motion to continue. And in doing so, makes clear, this is volume 1, page 9. I don't have an expert to support it. And I'll go back to page 8. He told me that he couldn't come to an opinion to a reasonable degree of psychological certainty or medical certainty. He's making this clear on the record.
He also says what your opponent points out. He says that I am going to present Dr. Joss, and I am going to pursue a diminished capacity defense. He says that.
And I think this
can we just take that as puffing, that that's not what he said to his client when they were behind closed doors, or do we need an evidentiary hearing?
No, I think that the silence speaks volumes. I think that the fact that both the defendant and the attorney were silent on what happened off the record speaks to the fact that the defendant has failed to raise a substantial issue, has failed to meet his high burden at this stage, and it does not necessitate an evidentiary hearing. I think it's a reasonable inference that this attorney did talk to his client off the record, and that his client was insisting on this defense, and it's the attorney's prerogative on how to effectuate the defense. I also think the defendant suggests that these plea offers were not off the table. They were still on the table. I don't think there's support for that one way or the other. To the extent they were still on the table, and by the end of the evidence, the defendant had not, or Attorney Madden had not done what the defendant was expecting, he could have gone to his client, could have put something in his affidavit about him wanting to take the plea at that point, and he still didn't. I think this is a hindsight claim.
You don't think it was off the table before impanelment started, did you? Do you?
I'm sorry,
I mean, if he'd moved for continuance and the judge said no, and before you started impanelment, Madden had come back and said, hey, my client actually wants it after all, do you think there's much chance Judge Spurlock would have said no to that?
I think that the record suggests that the judge thought this defendant should take a plea. He was open to a much more favorable plea than the Commonwealth had, or a more favorable plea than the Commonwealth had offered, and so perhaps he had been open to it. But the key in terms of the Loeffler prejudice is that the defendant had rejected both plea offers, and he did so specifically with respect to the judge's plea offer, as the motion judge found, being well aware that Dr. Joss would not be testifying in support of his lack of criminal responsibility defense.
Well, the judge finds that based on inferences, not on any direct evidence, because we don't know what was said. We don't know that he was told that Joss wasn't going to testify, and we don't know that he rejected the 15 to 18. The defendant actually says in his affidavit he was unaware of it.
And I think that's the motion judge explicitly discredited that, and I think that this court is bound by that, the judge discrediting it. I think that
Even though it was done on the papers, we're bound by that?
I think that a credibility determination, even though this court can look at the conclusions of law for error, I do believe that the credibility determinations that the motion judge made as to the affidavits are.
I'd be surprised if that's true, based on documents alone. But I hear your argument. Let me ask you this. Shouldn't the judge have granted the continuance?
No.
Why?
Because I think it was speculative on the record before the judge, knowing the procedural history, presumably knowing the facts of the case, that another expert would have come to a different conclusion within a reasonable amount of time.
Right, but the lawyer is sitting in a situation where he's learned, he says just today, but we actually know from the record it wasn't just today. But he says, I've just learned that I don't have the key to my defense. I need 60 days. I'm kind of lost. And it isn't as, I mean, we know from the record, it isn't as if he's making up the fact that he was trying. He was trying. He had somebody who conducted 2 interviews. He was a known expert who does this. Shouldn't the judge have given him a chance to pull together what his defense was going to be when the guts of it had just been cut out from under him?
I think the question is abuse of discretion. And in what was before the judge was that we can presume he knew that the defendant had been evaluated for competency. And I think there's no indication that he wasn't rendered competent. It had taken Dr. Joss over 3 months to evaluate the defendant. And
Is that a long time?
Dr. Joss says that it is a short time.
Yeah.
Short amount of time. So I think there's no reason, I think it's reasonable for the judge to believe that 60 days would have been insufficient to secure a second expert. The defendant, according to his affidavit, and presumably the judge knew this.
But see, we're all thinking of this, and I think you said this in your brief. You're all thinking this from the context of he's got to find another expert. He hasn't even shown he could find another expert. I'm thinking of it from the perspective of what is his defense going to be now that he doesn't have an expert? Should he still get up and say, my guy did it, which is what he did in opening? And the judge didn't give him an opportunity to try to figure out what he should do with his defense. The judge said, you're going to trial now.
To be clear, he moved to continue to retain another expert. He did not, despite what he says on appeal, move to continue to review his defense options.
Yeah, but he wasn't given much of a chance. He was cut off as he started by a judge who was impatient and did not allow him to say what his argument was. Isn't that a fair reading of the transcript?
I think that the judge was surprised. I think it's fair that this attorney had just said, Mr. Flavel is asking for a more favorable plea, 15 to 18 years, and it won't take me long to talk to him about it. I think a fair inference there is that the judge had, or excuse me, counsel had already spoken to his client, was coming on the record to ask this, and suddenly comes back on the record and counsel asks for a continuance. And I think that was very surprising to the judge at that point when he had just offered him this more favorable plea that he presumably was asking for, because counsel says Mr. Flavel is asking.
That wouldn't be a valid reason to deny a continuance because you were frustrated with the defendant's decision-making with respect to a plea offer.
That's fair, but I do think the other important aspect of this is that this claim was raised in the motion for new trial, and the defendant didn't make any showing then or now, then at the time of trial, or now at the motion for new trial stage, that a continuance would have had any impact on the outcome of the case. He didn't put forth an affidavit from an expert saying that they're, having reviewed the record or the records of the defendant, that he would have had a viable.
If he waived it, is is the continuance argument one that should have been raised on direct appeal or not at all?
Yes, although he didn't pursue his his direct appeal got dismissed.
Okay, yeah, but then does he get to raise that on a motion for new trial where he didn't raise it on direct appeal?
The Commonwealth didn't argue that. The Commonwealth argued that it was an abuse of discretion for the trial judge to deny this, nor the motion judge to determine that the trial judge hadn't abused his discretion, and that on this record, he did not make a showing that the outcome of the case would have been any different, having not put forth an affidavit from the expert, which I also think is important with respect to his latter claim about ineffective assistance of counsel going forward without an expert. Would it have been made a material difference on the outcome of the trial had he had an expert, and he hasn't made that showing. I also think it's interesting that he's arguing that the trial judge abused his discretion in denying the motion to continue, and at the same time is arguing that he wished he had taken this plea. So I think these are two kind of countering claims here, and I think that the parsing out of them is challenging. This needs to be looked at as a whole. The context here is incredibly important in terms of what this attorney was facing, and I think he failed to meet his burden in raising the substantial issue, and for that reason, the motion judge correctly denied the motion for new trial.
All right, thank you very much.
The court has no further questions. We'll rest on our brief. Thank you.
Thank you
Well
both.
argued. Yeah.
It's very well argued. This is a very interesting one, and we'll take it under advisement. All right, I'll call the next case, 23P 1000, Miranda versus Miranda. Whenever you're ready, Counselor.
Good morning, and may it please the court. My name is Kelvin Heinley, and I represent Colleen Miranda along with my colleague John Maiona, seated to my left. There are two, putting aside for the moment that we feel, and we were not trial counsel, but that we feel the facts and evidence presented to Judge Tierney at the trial court did meet the standard for an annulment. The central question that we are asking you to address today, as you can see from our brief, is that the trial court, or any trial court, cannot fairly and accurately decide whether the actions of an individual in the context of a marriage warrant a finding of fraud or reach the level of the granting of an annulment when you are using the wrong definition of marriage. And that is precisely what happened here. In the 3-page decision that was issued by Judge Tierney only about 3 business days after the trial, she cites a single case in support of her position, and that is the Chipman case from 1921. Chipman refers to the centrality of marriage as being the ensuring the non-bastardization of children in a civilized Christian society. And if that wasn't outdated enough for the court, Chipman is the progeny of Reynolds, decided 3 years before the Union Army defeated the Confederacy, which discusses marriage as being the centrality of it being to procreation and physical intimacy as an essential obligation of the wife in a marriage contract. The idea that any actions of any individual in the Commonwealth in the context of a marriage would be decided against the backdrop of those 2 cases and cited only to that case and not to Goodrich or anything since, we believe is blatant error of law. Goodrich redefined the concept of marriage in the Commonwealth 21 years ago appropriately to recognize that there are many reasons individuals in this state wish to get married. Sometimes they wish to have children, sometimes they do not. Sometimes they are capable of having children, sometimes they are not.
Can I stop you, counsel, and just, I've got a couple of questions, but the first one is, I just read Chipman this morning and I reread it. It doesn't say what you just said it says. Chipman doesn't say anything about. I mean, it simply stands for the proposition that it has to go to the center of the marriage, right? The language I think is used as the essentials of the marriage relation. That's all Chipman says.
All the cases back from about 100 years ago, where whether it's Anders, Smyth, Cummington, any of these talk about the centrality of the marriage, but they define the centrality of marriage as procreation.
But Chipman doesn't say that.
Chipman talks about the phrase of Christians, civilized, relying on Reynolds. It's the progeny of Reynolds, which discusses.
Yeah, okay. It cites Reynolds for a different proposition, which also seems to me to be, if not right, at least not also talking about what you're talking about. And Chipman doesn't talk about procreation. I mean, it's a fairly short opinion. I've now read it twice.
Chipman is a fairly short opinion, but it's the only opinion she cites, she being Justice Tierney. And if we're talking...
Are there more recent opinions that discuss what annulment, what the basis for annulment is,
well,
what the centrality of the marriage is?
Sure. There are more recent cases going to centrality of marriage, and if you look at things like Bosclair, Levy, Hansen, and Casson, all of which post-date Chipman and are contained within the materials submitted in this record appendix, I think what's fascinating about all of that is that they reiterate, for instance, Levy reiterates the Arno holding. It's a 1941 case that says having sex before the marriage is an absolute bar to annulment. One of the other cases, Bosclair in 1943, talks about a man being, it reiterates the third reiteration in that line of cases that premarital sex is a bar.
Let's accept your premise that these cases are older, and therefore they proceed from a different view in some ways of marriage, okay? How does Goodrich help you here? What standard do you think Goodrich stands up that should be incorporated, and why would that cause a different result in this case?
Sure. So if you look at Goodrich, where it talks about the centrality of marriage being this commitment to a lifelong partnership decided 21 years ago, if that's the lens through which Judge Tierney had viewed the facts of this case, we believe that the fact pattern of Mr. Miranda's behavior, both from the date of marriage forward and perhaps even leading up to it, establishes that he had a goal, like Mrs. Anders did in the Anders case, to achieve an immigration purpose, and that the moment the law allowed him
as a matter of, so that this was clear error on the judge's part. We have to...
That the application of these facts under the Goodrich view of marriage would result in the polar opposite decision that she reached.
Well, but I'm not sure that what the judge viewed is inconsistent with the Goodrich view of marriage. How is it? Where do you see what the judge said that's inconsistent with the Goodrich view of marriage as you've defined it?
So the judge doesn't say enough, which is part of my concern with the decision, which is when we have a 3-page decision issued about 72 hours after the trial, it cites only a single case.
That decision says, if there's a notice of appeal, I would like findings of fact, proposed finding of facts from both parties, and then I'll write a long decision. And you didn't do that. You didn't ask. Did you submit proposed findings of fact like she ordered?
The prior counsel, the trial lawyers on the case, they filed a motion for reconsideration of the decision, and then the trial court took no action after that. So we stepped in for the appeal and have appealed both of those decisions. But Justice Tierney and the court after that didn't accept anything further.
You tried to file proposed findings?
I apologize. Didn't invite anything further after that, after she denied the motion for reconsideration.
She said right in here, if you file notice of appeal, I want proposed findings of fact, and you never gave them to her.
Right, because they filed the motion for reconsideration instead, and then the window was such that we had to move straight to the actual appeal. I don't know that I can answer Justice Englander's question about how she might have applied Goodrich, because she didn't apply Goodrich. She cited only Chipman. And what I'm saying about the Goodrich decision...
Well, Goodrich isn't in the area of annulment.
Well,
right?
but that's exactly my point, is that it is because it defines the concept of marriage in Massachusetts, and annulment or divorce or anything. It defines how you enter a marriage, and all of these cases dictate how citizens of the Commonwealth leave a marriage.
That gets back to my question, how is what Goodrich says, what you pull from Goodrich is the standard you want to apply. How is that inconsistent with what the judge said about this and what she used from Chipman?
Because if the standard in Goodrich, which talks about a commitment to a lifelong partnership, are the words the Goodrich Court uses. None of the actions and inactions taken by Mr. Miranda meet that standard, and in my opinion, they don't
I
come
think the
close.
judge literally finds to the contrary. She talks about the fact that they dated for 9 months, that they lived together as husband and wife for 2.5 years, they had a child together, and that there was no evidence prior to the date when things fell apart that anything was going wrong.
And
isn't that an application of whether there was a lifelong commitment?
no, I
being
think the
together?
fact that there was no evidence of anything going wrong speaks exactly to the opposite point, which should have led her to reach the opposite conclusion.
Because your client left and took the child out of the blue because he wouldn't buy a house where he was solely responsible for the debt?
No, because the record showed that on May 13th, when they are set to go to closing on this PNS, they've got the offer in on the house, and he contacts Immigration Counsel and then suddenly and without warning backs out of that obligation and says to her, and there's no dispute that this part of the evidence was presented, I don't need you anymore for immigration purposes.
No, he specifically said he never said that. He testified he never said that. There's a completely dispute on that.
There was no dispute in her brief. He testified differently at trial, but there's no dispute here that that's what the evidence showed from her. And if he's decided to announce...
But so is your appeal based on the idea the judge had to credit your client and had to disbelieve the husband?
No, of course not. She has the discretion in observing the witnesses to decide which witness she
So the
credits.
husband testified that was never said. So why can't we affirm on the basis the judge could believe that?
Because it's not a reasonable inference to draw when you look at the larger context of his behavior, which is...
That he was a loving husband and that he had a child with her and that your client took the child and ran off to New York.
Right, and if you look at the larger context of everything that happened around that time frame, it can't be a coincidence, and this is where I don't think it was a reasonable inference to draw from a credibility perspective, that on the exact week he becomes eligible to proceed to the legal end that he wanted with immigration purposes, that he backs out on the day of a real estate deal. My client testifies, he says, I no longer need you for immigration purposes. It's indisputed that he calls Immigration Counsel, and it's indisputed that since that time, he has not petitioned for the child to come back to Massachusetts, that he places
Well, no, his
44 calls to
divorce
Immigration
complaint
Counsel.
specifically asks for custody of the child.
I didn't hear that, I apologize.
His divorce complaint specifically asks for custody of the child.
Yes, and they are currently litigating that issue in the state of New York, where he has asked for custody in New York, visitation, in New York. And the behavior that he exhibited, whether it was submitting applications, so if it all happens within the first week, he becomes eligible to seek the removal of conditions without his spouse's
I don't
assistance.
understand that point either. He didn't become eligible till May 25th, right?
Right, and so we're
So
talking...
this was May 14th,
Right, so we're talking...
11 days before he became eligible.
Right, and so right when he becomes eligible, the day he talks to an immigration attorney, suddenly he goes
Talks to an
from loving
immigration
and-
attorney because he's had a fight and he's decided that he doesn't want to go forward with the house. There's no evidence at all, as I understand it, of any evidence that he spoke to anybody before May 14th, right?
The evidence starts on May 13th, I believe, but it does start that day, that the phone calls happened that day. But he was contacting Immigration Counsel. I think the evidence talked about right out of the gate, he was taking photographs of her that she didn't consent to try to build a record of family involvement. And the first time they leave the house post the birth of their child, he makes her go to City Hall to get a copy of the birth certificate of the child.
Here's my question. Is it your position that the judge's findings are clearly erroneous, and which findings do you say are clearly erroneous?
The finding that is clearly erroneous to me is that the phrase from the Anders case that jumped out to me, in the Anders case, the court talks about somebody having a planned, studied scheme. Mrs. Anders knew she needed a last name to get into Germany with her
She left
child.
within a week, right?
No, she actually even, all joking aside, she left faster than that.
Okay.
But where it's analogous
It's a
to
little
me-
different.
But it's exactly on point in this way. She left the moment her marriage triggered the immigration end that she needed to meet, and so did Mr. Miranda. Those happen to be on two different timelines, but what they have in common is that they both left the marriage the moment the immigration law allowed them to achieve the end to which they entered the marriage for. That is what I think Judge Tierney got wrong, is I don't think you can take this set of facts, find it all coincidental, apply it against archaic definitions of marriage, and then reach this result.
I'm looking at the form. You can say my spouse is deceased. You can say my marriage was entered in good faith, but the marriage was terminated through divorce or annulment. You can say I entered the marriage in good faith, and during the marriage I was battered or was the subject of extreme cruelty. Or you can say the termination of my status and removal of the United States will result in extreme hardship. Which of those things happened on May 13th?
I would love to know, and that goes to my argument about the motion to compel and how Judge Tierney could have denied both the motion asking for him to sign the authorization to have the federal government turn over that form, the I-751 form, or her filing formal discovery after that motion was denied without any written explanation, the motion for reconsideration of that, because on that form,
which is it? Did he have all he needed for immigration purposes on May 13th, or did he not? Because you're saying both of those things.
So on May 13th, he was a few days, as Justice Ingledew just pointed out, about a week and a half away from being able to attempt to apply without his spouse's participation, but he couldn't do that under some of the criteria you just mentioned because they were, and in fact are today, still legally married. But if you look in the record appendix on page, I believe it's 85, the record appendix on page 85, the handbook for the federal agents that deal with these hearings, it says that the party at the hearing has to submit evidence within that form and at the hearing, quote, that the evidence that the marriage was not fraudulent and that it must speak to the bona fides of the marriage one way or the other. How that form and what Mr. Miranda said to the federal government on a sworn petition at a hearing that about evidence that established whether he entered the marriage in good faith or not could not possibly lead to potentially admissible relevant evidence is beyond me. That is the very definition of discoverable evidence. It is a sworn statement by a party opponent made during the course of litigation, submitted to the federal government about whether or not the marriage was entered in good faith. If we do nothing else, she deserves to see what he submitted to the federal government, and she deserved it then.
Is there any offer of proof at all in the record, anything that indicates how what was said there would help you?
The problem is, he objected. If you look at the...
yeah, you don't know what was said,
We don't know, but there are things that is in the record appendix from the trial court that actually are helpful. Number one, Mr. Miranda said, I have a post-separation right to privacy. He said that in his opposition to her motion to compel him to sign the authorization of the form. First of all, in Massachusetts, we don't have legal separation. There is no post-separation right to privacy. If you look at his opposition, there's no cite for a support of that because it doesn't exist. They were and are a married couple. This is discoverable evidence, and there's nothing in the record that gives any indication of what he said there because he said, I object to having to say what I said there, and he maintained that position throughout. Judge Tierney denied her motion to compel him to sign the form and then denied the motion to compel the discovery and the motion to reconsider all three times by simply stamping the word denied without a rationale. So there is nothing further on the record, but a sworn statement to the federal government about the bona fides of the marriage is the very definition of discoverable evidence.
Best case scenario, what could be in there that would be helpful to your client?
Let you
make it up. The best thing that could possibly be in there.
I just want to thank you for that. That's a nice, refreshing offer to just be able to make something up in an argument as I go. Best case scenario is he says in there that he has to admit that he contacted immigration counsel at a different time, that there was a clear plot, that he was submitting photographs to the federal government behind her back, that he was submitting birth certificates to the federal government. He was plotting this from day one. That and the fact that the form, the handbook for the federal government, talks about him having to establish that.
We have to reverse on this. We have to assume that he actually said in this form about why the marriage is in good faith that it wasn't in good faith.
It's not that he has to say it wasn't in good faith, it's that the hearing officer has to find that it wasn't in good faith.
I didn't think you were asking for a hearing, I just wanted the form. Wasn't that the motion?
And we can't get to that, we can't get to any of this without him signing the authorization form that my client filed a motion asking the judge to compel him to
Your
sign.
client had all of his records from his phone as to who he'd communicated with over the entire course of the
records,
marriage,
yes.
right?
Phone records.
Yeah, and there's nothing that supports what you just said prior to May 13th.
There's nothing
There's
that
no
support-
indication that he had been contacting Immigration Counsel. There's no indication that he'd been contacting somebody about what he should say. It's not there.
Not in the phone record that she had, but how on earth is she supposed to know if he doesn't have another phone? How's she not supposed to know that he wasn't making in-person meetings?
That, it seems to me, is more direct discovery than asking the United States government to turn over a document as a third party. You could have pursued that discovery. You could have said, hey, we don't think that he's being honest about what he's producing. But there's no evidence of that in the briefs.
So to be fair to the trial counsel, because again, I'm only the appellate counsel and I realize I'm way over, is she did try to pursue just that. The simplest route to getting to the bottom of what he claims were the bona fides of the marriage was what he said on this form and at that hearing. And instead of going to the third party directly, trying to subpoena the federal government, she asked the court through her trial counsel, please ask him to sign this simple release. The judge said no. Then she turned to formal discovery in the form of a motion or a request for production of documents. The judge said no to that too. She tried both. She was turned down without explanation. It's simply stamped denied.
All right.
Thank you.
Thank you very much.
Thank you very much.
We'll hear from counsel for the husband. Whenever you're ready, counselor.
Good morning, Your Honors. Victoria Aaron Carboni on behalf of Defendant Appellee Arion Miranda. The plaintiff appellant is inviting this honorable court to redefine an established legal rule that's applied in annulment cases involving allegations of fraud in the inducement. The defendant is respectfully asking this court to decline that invitation. Now is not the time, and this is not the case. Why not? First, the Chipman v. Johnston decision did not or was not overturned by the Goodrich decision. Second, even if it had been overturned by that decision, the result would have been the same, and therefore there would have been no prejudice to the plaintiff. And finally, the motion to compel, which was just discussed by counsel, was properly denied.
Is there anything inconsistent between Goodrich and the standard that Chipman talks about?
From my reading, Your Honor, no, there is not. First, as a preliminary matter, I would just note, as I argued in my brief, that I do believe that this issue is waived. It is presented for the first time on appeal, and for that reason, I don't think it warrants consideration, but nonetheless, to the merits of that argument.
Were there any briefs to the judge pre or post-trial with respect to what the standard was for annulment?
Not to my knowledge, Your Honor. There was a post-judgment motion filed, a motion for relief from judgment, and I believe for new trial. The only grounds for that motion were Rule 59 of the Mass Rules of Domestic Relations Procedure and then 60B3. So that was, I think an argument by the plaintiff.
Fraud on the court?
Yes, fraud, misrepresentation, or some other misconduct. There wasn't any 60B1 argument or even a 60B6 here to be had. So it's for that reason that,
So if we were to comb the record, we wouldn't find anything before the trial court that argued even what the standard for annulment is. Didn't argue Chipman either.
That's my understanding of the record, Your Honor, that this issue was not raised, that the incorrect legal standard had been applied in the judge's decision. So back to your question, Your Honor, about whether or not the proposed standard or rule as proposed by the plaintiff is inconsistent with Goodrich. I don't think it is. I think that the cases, yes, they're old. Chipman, 1921, Reynolds, even earlier than that. Some of the subsequent cases, including Mistal, Smyth, Hansen, they come from, I think, the early half of the 20th century. But nonetheless, even in those cases, there isn't this explicit discussion of a prerequisite or a necessary for a valid marriage that there needs to be procreation. Even in Goodrich itself, at 961, the SJC observes that people who have never consummated their marriage and never plan to may be and stay married. And they cite for that proposition a case from 1898, Franklin v. Franklin. So again, I don't see that.
I mean, a
this-
rule that says we're not going to annul a marriage without fraud that goes to the essence of the marriage. I have difficulty. What's wrong with that rule? That's the rule that Chipman talks about. And do we have any difficulty with that rule?
So, no, Your Honor. So the issue, I think, the argument that, as law custom has evolved, that perhaps maybe societally, or even, also just stick to societally, that there's a different understanding of what, or maybe an evolution, I'll say, an evolution of what marriage is as understood now, as opposed to at the time that Chipman was decided, or even the cases like Reynolds that Chipman relies on. There is.
Well, that's certainly true.
Nonetheless.
That's certainly true, but we're talking about the rule.
Right.
What is it that is a basis for annulment, right?
And here it's more than that. It's, a basis for annulment that's alleging fraud in the inducement by one party. So even if, marriage has evolved over time, as law and custom have evolved, the idea that spouses have duties or obligations to one another, which is discussed in Chipman and some of these related cases, there's this emphasis on, duty that one spouse has to the other, and that's central to the marriage. That in and of itself is not entirely inconsistent with Goodrich. Even if we look at the language of, the exclusive and permanent commitment of the spouses to one another, that is a duty. So I think the discussion there is in Goodrich not inconsistent with those cases. For that reason, I don't believe that Goodrich has overturned Chipman. I think the trial judge properly applied the standard in Chipman v. Johnson. If we look at some of those cases, particularly Hansen, Safford, Mistal, which are discussed on page 19 of the defendant's brief, there is an emphasis on those cases which concern allegations of fraud in the inducement of what the party knows, the party who is alleging fraud, what they know at the time or before the marriage. And if we look in this case, what the plaintiff knew, the plaintiff did know that at the time of the marriage that the defendant was not legally in the United States. She testified at trial that she knew that the defendant had overstayed his visa and was not legally present. She also testified that she knew before the parties were married that the easiest and fastest way for him to obtain legal residency was to marry a U.S. citizen. And still here, the argument is that, or still, even in light of those facts, she pursued him. She was the one who initiated contact with him. She reached out to him. They dated 8 to 9 months. They got married. They had a marriage of about 3 years, lived together, had a child together. Even when the child was born, after the child was born, the defendant financially supported the family. And even after all that, the argument is that from the start of the marriage, that the defendant had made some secret or concealed some intentions from the plaintiff, and the facts, the defendant argues, fly in the face of that, in that argument falters. As for, the proposed redefinition of the standard, assuming we say, okay, fine, let's look at this redefined standard and apply it to the facts of this case, I think that even if that's the case, that the result would be the same. Again, there's a reliance by the plaintiff on the Anders v. Anders decision. In that case, there was an immediate abandonment of the marriage by the wife. I think it was the same day.
She left the ceremony and then went to the dentist, correct?
Yes, or so she said.
Dentist.
Yes, she said she was going to the dentist, she'd be back in the afternoon, and then.
Then she was on a flight.
Yeah, or I think it was a train. But
Going to the
nonetheless, she
dentist was a
traveled.
much bigger deal back then.
Yes.
Well, it was in Germany.
Right, maybe that's where the dentist was. But nonetheless, if we're looking at the time here, I think there's an argument in the plaintiff's brief that the defendant pivoted away from married life in such a way that would suggest that he did not have this exclusive and, permanent commitment to his wife, and that is just not the case. Again, as I stated, previously, the parties lived together for some time, dated 8 to 9 months, were married for 3 years, had a child together, and that certainly just.
The judge made some findings. It seems a bit of a case that no good deed goes unpunished. She wanted to get this out quickly for the parties' benefits with the parties' agreement. So I didn't address counsel, but he spoke a little bit pejoratively, like she did this quickly and with a quick sight. And as Justice Ditkoff stated, she asked for further filing if there were to be an appeal. But my question is, do you think there's sufficient factual findings, credibility determinations currently on the record if we were to review under a new standard? For instance, if all the trapping, the vestiges of these prior cases do perhaps drag down the definition of marriage, so it complicates the issue of annulment. Just grant me that. I know you're not granting that, but just grant me that Goodrich has changed the standard. Do you think there are sufficient facts if we were applying a new standard and credibility determinations made?
Yes, I would say so. And further, I would just note that there are no, from my reading of the plaintiff's brief, there are no challenges to any of the factual findings that the judge had made. Again, it was an argument that the improper legal standard had been applied, but no argument that, there was an error in any of the judge's findings. And further, I would note that the judge did find that there was no evidence in the record of any sort of sign that this marriage, that this relationship was not going well until around May 13th or May 14th, when there was this dispute over the purchase of a home. And the plaintiff makes much of this dispute, and further the calls to counsel that the defendant made shortly before the closing, or the scheduled closing, and shortly thereafter. But as I argue in my brief, that's not entirely unreasonable. Those calls were not entirely unreasonable for the defendant to make, given the circumstances of this, given his status in the United States, and further, given this huge purchase that he was about to make, and he was going to be the one that was on the mortgage, that's my understanding of the record. And further, the plaintiff left after their dispute without telling him where she was going with their young daughter. So I think that, those facts, in and of themselves, don't suggest that 4 years prior, when the defendant met the plaintiff, that he was scheming and calculating, to have this rift at some point and to abandon the marriage. I think the facts suggest that there was an abandonment, but in fact it was by the plaintiff. She was the one to leave with the child.
Shouldn't the judge have allowed the discovery of what your client said to the United States government?
The motion to compel?
Yeah. Well, yeah.
Yes.
Motion to compel.
So my understanding of the plaintiff's argument, I believe, was that there was error in the denial of the motion to compel his signing of this authorization, the document. I'm not sure that I can't say what was in the form, but I'm not sure that what was in the form would have been relevant. If not, it was just, a statement that it was a bona fide marriage. Again, I can't, hypothesize as to what was in that form, but I'm not sure.
It's not really an answer to my question. Shouldn't the judge have allowed the discovery? Because the discovery had to do with what this guy said what your client said to the United States government about his marriage.
I don't think so, Your Honor. I do not think that it was an abuse of discretion for her to deny that motion. Again, I don't think what significant relevance any statements.
Does he have to, when he's making his request to remove the conditions, does he have to talk about the bona fides of the marriage that he's in?
I do believe that is a part of the form.
Seems relevant.
I mean, my argument, I think we don't even need to get there. I think with the facts of this case, I don't think we even need to address that issue again, because I think that the correct legal standard was applied. But from my perspective, there was no error, no abuse of discretion in the denial of that motion. And I believe that just one final note before concluding, there was a request for fees pursuant to Mass Rules of Appellate Procedure Rule 25 in my brief, and with that, I would rest on my brief if there are no further questions from the panel.
All right. Thank you very much. I'd like to thank our interpreter. We don't usually get interpreters here, so we appreciate the interpreter making the travel here. Counselor, really well done. I hope we'll see you more in this court, and of course, I know we'll see your friend. Very obviously, he's a very experienced litigator here. With that, we will take our break, It will not be longer than 15 minutes. And we will stand adjourned till then.
Court is now in recess. Be seated.
Just a sec. All right, we are back in session. The case is 23P 381, John Doe number 132084 versus the Sex Offender Registry Board. And Counselor, whenever you're ready.
All right, thank you very much, Your Honor, and may it please the Court. My name is Ethan Stiles, and I represent the petitioner, the offender in this case. And we're here today because we believe that the hearing examiner wrongly denied his motion for funds, which touched upon all three of the factors which the SJCA identified in Doe 89230 is particularly worthy of consideration for expert funds, namely the debilitating medical conditions, diagnosis of a mental abnormality, and opinion on risk of reoffense from a licensed medical professional. And we have all those in this case. The debilitating medical, well, he has a few of them that could be. The one that was given the most prominence was Eagle syndrome, which is a rare syndrome which has been described, and it can cause pain to the throat and face, and chronic pain leading to depression, anxiety, and pain when eating, talking, or turning the head.
Am I correct, there's nothing in the record that links...
I'm sorry, Justice.
Am I correct, there's nothing in the record that links your client's Eagle syndrome to a loss of the ability to engage in sexual assault?
Not explicitly, Your Honor, but the literature does talk about the potential symptoms, and the letter from his treating psychiatrist, Dr. Sarah Segal, talks about multisystemic losses. So,
but aren't we talking about it in the abstract? And doesn't the case law say that we need to talk about it in the specific? In other words, as it affects your client?
As it affects my client, yes. I mean, we do have in the record we do have a discussion about how it can affect my client. However, we do not have an explicit connection between that and sexual dysfunction or a loss of ability. However, I think the inferences can be made that there may be a correlation to be made. Now, I would point out that Eagle syndrome is a rare syndrome, so the studies on that and loss of sexuality may not be as concrete as it may be for other things such as diabetes or hepatitis C.
But I don't understand there to be anything in the record that suggests that Eagle syndrome leads to a loss of sex drive.
I think that's why we need the expert to make that connection. And if it is there, an expert would need funds to do that. We do have the treating psychiatrist who talks about that, and I think he would be inferred that he could give an opinion on that subject. However, of course, it's sort of a chicken and egg problem, which comes first. You can't expect experts to do research and opine on rare conditions without funding, and that's what he asked for, and was not given. But yes, I mean, if you compare the symptoms that are talked about,
well, in Doe 58574, there were actual studies that then someone could testify about. I mean, you're not suggesting we're going to start randomized studies here and hold it out without some evidence that there's some evidence. What could someone testify to?
We don't know if there are studies on the subject. The ability to research those might be best done by a medical professional rather than my predecessor. But we do here have, and if there are not studies done, the expert may be able to make a credible opinion analogizing the symptoms suffered by Mr. Doe, not just Eagle syndrome, the other issues, the loss of vision, the hypolipidemia, the hypertension, all those combined factors may be analogous to the diabetes in the one case and the hepatitis C in the other. But we just don't know that because we don't have the expert here. So now the second factor is the diagnosis of a mental abnormality. Now in this case, the board included a report from Dr. Pierce, I believe.
Just stay on the first question for a moment before we turn to the mental abnormality, the doctor's report. Why isn't there an affidavit from your client? That's within your power. in order to say, hey, as a result of having the following symptoms, which I have, the following things have happened to me?
Well, I think the affidavit was not included. Perhaps it could have been, but there were medical records from third parties which were not prepared for the purposes of a hearing, which do talk about his symptoms, his limitations. One of them talks about they may have appeared more genuine in that respect than rather than if he just put in an affidavit for the purposes of a hearing as opposed to his medical.
So what, if I'm going to go take a look at these additional documents, what are they going to tell me about the impact on your client from, for example, Eagle syndrome? The treating psychiatrist, considered that he had multisystemic losses as a result of the rare syndrome. What does that mean?
He doesn't go on much to explain, to go into detail on that. I mean, I don't believe that the letter was intended for the sex offender registry, so I guess, in some sense, you have to take what you can get. We have from another physician talking about his loss of vision, and they talk about how that he believes he should give up his driver's license. And I think that should also be considered, because if the allegation is that he's going to bus stops and accosting young girls there, he might find that more difficult between the loss of his license and the pain suffered from Eagle syndrome. So again, we do have some record evidence in there that suggests that this man's conditions are debilitating. How debilitating, I think, should have been the subject of expert testimony and examination.
What do we do with the fact that the article that was submitted to the examiner says that Eagle syndrome can be effectively treated almost all the time?
Well, there was that article, and it talks about surgery. Now, there's another doctor's report in the record where the doctor lays out the risks of, talks about some of the risks of surgery, and notes because of the rarity of Eagle syndrome, he's never done the procedure before, and he says, I'll study up on it, and do my best, but he's kind of. He just doesn't have the experience with it, and maybe hard to find, considering the relative rarity of this condition. So I think it's a question of does the petitioner really want to go forward with this risk, the risks that may be inherent in the surgery for Eagle syndrome, because they're going in through the neck there, versus living with it, and how should that play out in the context of the sex offender registry?
That's sort of the question. When an examiner is facing someone with a condition that he can easily get corrected, or not easily, but that there's a treatment that's almost always effective, does the examiner evaluate their dangers assuming they won't get it treated, or assuming they will get it treated, because he can't reclassify for the treatment or put a condition on it, can he?
No, I mean, ultimately it would have to come down to what an expert would say, because undoubtedly I would believe that one of either attorneys, even the examiner himself, could ask the question, has he been treated? Is he willing to treat? What does he want to do here? And then make a decision based on the probabilities of the treatment. And of course, and I would also note that this Eagle syndrome doesn't sound like a condition that improves with age. I mean, he was 69 at the time of the hearing. He had been diagnosed some time before that. So I think that, again, that, when one interplays the calculus of conditions and age, one may find that a 69-year-old level 3 might be a bit unreasonable. Now, let me turn to the diagnosis of the mental abnormality, because the SORB introduced in the record a report from the SDP petition that said that he had...
Is SORB required by statute to put that in?
No, I don't believe it is. However, they have the...
But there's some statutory language about it, like it does come in, prior SDP reports do come in for purposes of this, right?
I think the statute definitely allows them in under the of any information useful, and that was certainly within the scope of the statute. So it's come in, but ultimately, and it says that Mr. Doe has a mental abnormality. He suffers from pedophilia. He may have an unspecified personality disorder. Now, that wasn't enough to get Mr. Doe committed, but it was certainly the hearing examiner did take that into some consideration.
Well, what do you mean? You say that took it into some consideration. Reading what the hearing examiner said, the hearing examiner said, I'm aware of this, but I give it no weight.
I don't believe he said that. I believe that in the discussion section, the last section before he gives the conclusion, he does say, I gave it some weight, some consideration. I believe those are
He gave it some consideration.
Yes. Now, it should be noted.
In which the consideration says this was in 2014 and it had to do with, you know, this particular, it indicated that there was a particular mental abnormality, but I don't find it very useful because it's not put in the terms of the standards for determining whether someone should be registered and at what level.
You know, roughly paraphrasing, that appeared to be his approach to it. However, you know, it wasn't that he did not say, I give this no weight. And I think, you know, when one asks for funds, one is asking for funds before the hearing examiner has made any determinations of fact or conclusions of law on the issue of the petition. So when one sees that there's the valuation coming into effect, that does implicate the diagnosis, and therefore a petitioner would be well advised to ask for a motion of funds to challenge that, to say that relies on outdated information, that the personality order is, you know, the mental abnormality is in remission, the personality order isn't very helpful without some specificity. You know, essentially that's what he would that's what you would expect an expert to testify to if the board was going to you know, introduce evidence, because the petitioner and his attorney doesn't know how much weight the hearing examiner is going to give. So, you know, essentially the hearing examiner, you know, shouldn't be making a conclusion that's going to deny a person's motion for funds before they've actually heard the evidence. And then lastly, I'll touch briefly on the opinion of risk of reoffense from the licensed mental health professional. Now, in this situation, the treating psychiatrist did say that the petitioner had a low risk of reoffense. It's in one of his letters, and the hearing examiner denied that on the basis of the doctor didn't testify at the hearing, and therefore it's excluded under the regulation that was cited. Now there's the third argument where he says he already has an opinion of low risk. You know, any reasonable offender with means who had the means would go and seek out an expert to offer that opinion, to perhaps to flesh it out a little more, to to make it a little more current. But essentially, that there's the third element, which allows for for him to actually ask for the funds so he can actually present this in the procedurally proper manner, and that was not granted, and essentially, but it was excluded, and therefore whatever value that opinion may have had from his treating sex offender treatment provider was not put in the record. So ultimately, we're asking the court to reverse and remand for further hearings on the subject of the motion for funds for an expert. And if there are no further questions, I would rest on my brief.
All right, thank you very much. We'll hear from the board now. Whenever you're ready, Counselor.
Thank you. If it pleases the court, David Chennai for the board. The board's position is that because the hearing examiner did not consider Dr. Pierce's report in the classification decision, and that the plaintiff failed to bring at least the threshold showing that the physical ailments impacted his sexual performance or ability to commit a sex offense, that the hearing examiner properly, after hearing all the evidence, denied the motion for expert funds. It's always been my position that the less that I have to say, the better for myself. So unless there's specific questions, I'd be more than happy to rest on my brief on these issues.
Well, if the examiner had relied on the SDP report, then we have to send this back, right?
Well, I knew you were going to ask me a question, so on that one.
Why you stopped early, Mr. Chennai?
No, if the hearing examiner had considered the mental abnormality part of that report, I mean, if the individual made statements in the report about prior sex offenses or things that he may have done, the hearing examiner might be able to consider that. Or if the individual talked about substance abuse, the hearing examiner consider it. But if he's going to talk about the mental abnormality part, and the hearing examiner accepts that, and then applies factor one, and there was a motion filed for experts, I think that should have been allowed.
So you don't think that, so you don't think there's a problem with not giving money for an expert until the examiner actually affirmatively says, I'm relying on this? That's the position you just articulated.
Right, because in this case is a good example. The hearing examiner didn't make the decision on expert funds until they looked at all the evidence. It was in his decision, the final decision. What would happen in that circumstance if he decided that Dr. Pierce's report required, that he was going to use mental abnormality, pedophilia, and then an expert was required, then a second day of hearing would have been granted, and he would have been allowed to get an expert. And that happens, pretty routinely now. What I'm saying is that there are, any type of report that comes in, there are portions that don't deal with either the risk opinion or the diagnosis of a mental health issue that can be considered. A tangential issue such as criminal behavior, if it's in the report, or additional issues about substance abuse, things like that. But unless the individual testifies, the hearing examiner
Not
can...
related to the opinion component of being an expert, right?
Correct.
That's what, they're fact. They're
Correct.
fact issues, they can be addressed as fact issues.
Correct.
That's your point. But I guess what I'm stuck on is Commonwealth puts in a report. This person has serious mental abnormalities that cause them to be a sexually dangerous person. And under those circumstances, even if the examiner doesn't say, and I rely on that, doesn't the defendant get a chance to say, that's just not right? And the only way they can do that is through an expert.
Well, they have the right to say that, but again, the burden...
The only way that they can do it with any effectiveness is through an expert, right?
But I think we're putting the cart before the horse. If the hearing examiner is not going to consider mental abnormality, and again, in this case...
Say I don't consider it. Your opponent is right. He didn't say I give it no weight. He did come darn close, but he didn't say that. He said, I do consider it. I've read it. Here, I'm going to spend 2 paragraphs explaining what it says.
Right, and basically, because it's in evidence, he has to consider it, and what he did in the end is said that he gives it little weight. And he definitely made it clear he doesn't rely on the issue of pedophilia, and he doesn't rely on the ultimate risk opinion that was in there, because he was using a different, and he specifically said, I'm not using SDP standards, I'm using the board's regulatory factors in making my decision. And again, if he's not going to apply factor one, mental abnormality, and he's basically saying this was a 2014 report. There's no evidence that he currently suffers, and he specifically says currently suffers from pedophilia. So the hearing examiner said, I'm not going to consider that in my decision. Now, the whole idea of expert funds is if
That
there's...
seems counterintuitive to me.
Well, the whole idea of expert...
Somebody for at least a decade has been suffering from pedophilia, right? So why do we assume it just went away 5 years later?
Because we don't have an actual diagnosis other than a 2014 diagnosis. And more importantly, the whole idea of the board of expert funds, I think 151564 talks about it directly, is that it is designed to give funds to get an expert to assist the hearing examiner on a specific issue. The hearing examiner didn't need assistance on the issue of pedophilia because he didn't find that pedophilia was a current diagnosis that should be put forward. Now, if you got to look at it counterintuitively, if the expert's hired to say, oh yes, he presently suffers from pedophilia, that's not very helpful to his case. In this situation, the hearing examiner is saying, I don't find that the evidence supports a finding right now that he suffers from pedophilia. And we all know that pedophilia is, although it exists in an individual, it can be in remission or not an issue if there's 6 months showing that he hasn't...
You say we all know that?
Well, I think we've all seen enough cases, at least on my end, we've discussed this enough times to know that, experts come in all the time and say, he hasn't engaged in pedophilia behavior in 6 months, therefore I cannot currently diagnose him as suffering from pedophilia. So, I mean, that's in there too. I think once the hearing examiner said, I'm not going to consider pedophilia, there was no need to have an expert to help him assist in the issue of how pedophilia impacts this individual's current risk and danger.
All right. Thank you both.
Thank you, Your Honor.
Always a pleasure to see both of you. I'll call the last case on the list, 23P 1068. I want to remind everyone this case is impounded. We won't be using any names. We'll say mother, father, grandmother, and I want to make it very clear we will use child. We will not use the child's first name. We will say child for the child. Counsel, whenever you're ready.
Thank you. Good morning. May it please the court. I am Attorney Jennifer Lamanna, and I represent the maternal grandparent and petitioner in this matter. The only issue remaining before this court is a legal one. The factual arguments that my client advanced are now moot. The child has been adopted, and she will not see him again. However, despite the adoption, I still think that it's appropriate for this court to address the issue that clearly plagued the lower court, which is who has the burden in a Chapter 119, 26BA
So you concede
petition.
mootness? You concede mootness?
I do. I think the statute is very clear that it's for a child in foster care. We did not learn, because of the rules of impoundment, that the child had been adopted until we received the department's brief. So the maternal grandmother had no way of knowing at the time that she was preparing for and briefing this that that door had been closed. And because her relationship had been shut off in the late winter, November, December of 2021, at that point in time, at the time that the adoption was apparently finalized, according to the information we now have, there was no redress for her.
Do we have cases that say, even though the case is moot, we can go on and address an issue that's raised?
Indeed. And I think it is very clear that there is a level of confusion at the lower court level as to what the appropriate standard is. And it has been fully briefed, at least on the issue of what the burden is.
Oh, no, you've jumped.
Oh, I'm sorry.
My question is, you're conceding mootness. I'm not suggesting that you're wrong about that. It's very hard to see what relief could be granted. But if the case is moot, do you have cases that say we still have the power to go on and do what you're asking us to do?
Well, there is certainly case law, quite a bit of it. Brach is the first one that comes to mind. It's an SJC case, of course. And there are a number of cases, they often seem to involve tax cases, where the court talks about the fact that if something's capable of repetition, if it's in the public interest, that the court still can opine and give guidance.
That's capable of repetition yet evading review. Okay, so there are some exceptions. Here, I don't know why it would be evading review, although maybe it's not going to be uncommon on appeal that an adoption has occurred in the meantime, so that the issue is going to become, the legal issue is going to become unavailable.
Well, it's also the public interest issue, certainly. And again, because of the nature of these cases, the timeline, so very often in the cases that I looked at where it's capable of repetition but evading a review, you have a situation where whatever is being challenged is happening on a very short timeline.
Right.
And because of that, every single time you finally get up to the court, either someone's license has been reinstated or whatever, and the executive order has been rescinded. This is quite different because, of course, care and protection cases can take a long time or a very short time. If parents stipulate determination, a child could be cleared and adopted on a very short time frame while the grandparent is still seeking their hearing, briefing it. The timeline for this was horrible, quite frankly. My client's petition was filed in June of 2021. The hearing didn't take place until March and May of 2022. Because these petitions, for reasons which are unclear, are treated under the same docket as the care and protection case, the grandparent has no ability to check the docket, find out what's going on with the case. As your honors may have noted in the the appendix that we attached, the docket that we received is heavily redacted. And because the grandparent is not an actual intervener in the case. And so the petitioning grandparent under 26BA has no ability to track the status of the underlying case. So that's one thing that could certainly be addressed. The other part, of course, is the fact that the court in this case articulated at the outset a very clear standard, identified that the grandmother had made the initial showing that was required, that she had identified herself as the biological grandparent of a child in the custody of the department, not there voluntarily, and therefore the first and third paragraphs of 26BA applied, and that therefore, said the judge, the burden shall shift to the department, and it shall be by clear and convincing evidence to determine that it's not in the best interest of the child
By
for there to be
preponderance.
visitation.
She said by preponderance of the evidence.
He said clear and convincing, and then in his ruling, he shifted it. So the reference to the clear and convincing, he
Right,
stated,
In the ruling.
In the ruling, you said preponderance.
the ruling said preponderance. So at the outset
So
of the
his first
hearing,
reference is to clear and convincing, but he's not bound by that. That's an interlocutory statement, right?
it's an
Change your mind,
interlocutory.
judges change their mind.
It is an interlocutory statement that established who had the burden of proof and what it was. And of course, for a grandparent petitioning under this statute, if you do not have the burden of proof, if the department has the burden, the Department of Children and Families has the burden of proving that your request for visitation with your grandchild in DCF custody.
Are you doing that from the language of the statute? Because
I thought the judge at the hearing said the department had the burden to show clear and convincing evidence.
Correct.
Right.
That's correct. And then
In
in his ruling, he determined that the grandmother had failed to demonstrate by a preponderance of the evidence that visitation would serve the best interests. And so he flipped it. And that is, of course, a critical determination, not in this case anymore, because the facts don't matter anymore. I understand that. But in any other case that comes later, where the facts do matter, if you have the burden of proof, and what that burden is a critical factor in determining, for example, in this case, I can address, the guardian ad litem. So the guardian ad litem submitted a report. If one had the burden of proof, one might want the guardian ad litem to testify and cross-examine them. If one did not have the burden of proof, one would assert that the inadmissible opinions that were contained in that report would require the guardian ad litem.
Are you claiming
being
that
called.
that your client was misled by the statements that the judge made?
Yes, oh, certainly. To walk into a hearing under the impression that the other party had not only the burden of proof, but needed to do so to prove that visitation was not in the child's best interest by clear and convincing evidence is a very different situation from being told at the beginning of the hearing, you have the burden of proof by a preponderance of the evidence. It's an enormous difference.
That's a little different. I mean, that's a little different than worrying about the legal question, qua legal question. Now that's my fault because I asked the question of you. I mean, the language, unless it is determined by the court or the department that grandparent visitation is not in the child's best interest. So you say that shifts the burden of proof as a matter of law to the department in the proceeding about grandparent visitation, right?
Yes, I do say that. I think unless, the term unless is language of presumption.
Could you read it to simply be that the department has the burden of production unless it is determined by the court or the department? So the department has the burden to produce evidence from which one can conclude it's in the child's best interest that there be no visitation. Why isn't that a reasonable reading of the statute?
So the grandparent then has established, simply by establishing their status as a grandparent, and so the department now has a burden of producing some evidence, however scant.
They've got a burden of production. They've got to produce enough evidence from which a judge could find that it was not in the child's best interest.
Well, I think that, again, the language of the statute which is, I think,
just
firmer
read it.
than that. I don't think it's just a burden of production. I would argue that it is not, unless it is determined by the court or the department that grandparent visitation is not in the child's best interest,
So-
and then there's a list of the
So
things
here,
that should be taken into
here
account.
the department determined it wasn't in the child's best interests, right?
Yes.
And so when you come into court to challenge, that's enough to satisfy the statute. When you come into court to challenge the department's determination that it wasn't in the child's best interest, why wouldn't you have the burden to show the department got it wrong? Because the department's determination itself is enough to prohibit, to withhold visitation.
I think there are two issues with that being the case. I think first is the comparison between the language that, because there is case law, of course, about the sibling visitation portion of 26B. And that language is different, and I think in important ways. In the court, so when I look at this from the language that the court in adoption of Garrett and in Imre Jamison used to determine that the burden of production shifted the burden of persuasion to the sibling. And the court specifically addresses the or language and specifically addresses the or language between the department or the court, and specifically indicates that the way the statute is written, there is deference given to the department's determination. Section 26BA is written differently. It shall be, the court it says the court and the department shall ensure that a grandparent of a child who is in the department's care shall, upon that grandparent's request, have access to reasonable visitation, and that the department establish a schedule. And unless it is determined that it is not in the best interest. And it says the court or the department, and again, that comes back to that sort of unfair surprise, which doesn't matter going forward as long as courts are articulating the correct standard. This won't be a surprise to anyone else. But I would suggest that if it's just a burden of production, and the burden then shifts to the grandparent to show why it is not, I would say there's nothing in the language that leads to that conclusion. And the structure.
Except that she's the moving party. She wants to change the status quo. So frequently, that's the way we decide who has the burden of proof.
The issue, because the department and the court are required to, shall ensure visitation, the nature of this type of petition is necessarily a review of what DCF has done. Because if DCF is providing visitation that the grandparent is happy with, the grandparent is unlikely to petition. So a petitioning grandparent is automatically in a position where they're challenging either the department's
Right.
refusal.
And so so it's the nature of a motion. It's a motion that says, give me visitation. The department has said no. Now, I think, and I don't know how anybody else thinks about it, that it might be a reasonable way to look at this to say, well, if the department has made that determination, that's statutorily required. Either the court or the department has to make it. That means the department, we're going to presume, was rational and has a basis for that, and that you start the proceeding by the department producing its reason why it said no. But ultimately, the burden of persuasion could still be on the moving party.
It certainly could be. I mean, I think that, respectfully, that it is for you justices to determine, given that I think the language can go either way. And I obviously, again, in this case, we were very much directed by the court saying, they have to prove it, and this is the standard. But I certainly think the language is open enough to treat the grandparent filing a petition here as a moving party with the burden, if the department has established, similar to under the cases under Jeremy and Isaac, where when the department has custody of a child, the department's decisions regarding basic issues of custody are treated the same as a custodial parent, and it's analyzed under the abuse of discretion.
Did you consider filing a reply brief with respect to the mootness issue?
I'm sorry, I didn't hear that, Your
Did you
Honor.
consider filing a reply brief? The mootness issue is raised by the department in opposition, right?
By the department. I did consider it. My client is of extremely limited means. And this was an absolutely devastating piece of information to discover when she learned that due to the adoption, which had taken place after the briefing and the costs that she's already sustained for that, that it doesn't matter at this point. That was crushing. So we discussed that, and quite frankly, I wasn't sure that I would ever end up standing here in light of the issue raised by the department. And I know that I was very surprised, I think, when Your Honors requested that we address the interlocutory aspect of it. I thought it was going to be something entirely different that you were going to be asking. But since we are here, and since you did read the briefs, that I do think it is absolutely appropriate for you to give the rest of us some guidance and articulate what it is that you think is appropriate based on the statute as it's written. It's certainly an area of law that comes up again.
There's no case law really that's going to tell us what the answer is here, right?
There's nothing. There's even under Garrett and Jameson, which again is the sibling statute, the courts there kind of waffle back and forth because under 26BB, there's two sets of language, right? So one paragraph says the court and DCF, same as 26BA, and then there's another paragraph that says either one of them shall ensure, which led the Garrett court to say, if it says or, that means the court is under no obligation to issue an order. You don't have that language in Section A, which I think kicks us back to that argument that the court does have an obligation to make a determination if a grandparent has brought a petition. And Jameson, which was a guardianship case, Garrett specifically says, we're not reading Jameson to require a court because of that or language that appears in the second portion of Section B of 26B. But you don't have that under 26A, and I think that really, at the end of the day, comes back to this very specific point, which is that there's an enormous difference between...
We're past time.
I apologize.
But I would like to say that I think I speak for all of us when we appreciate your, regardless of what we wind up doing, appreciate your client sticking with this, and we appreciate you sticking with this appeal.
Well, thank you.
Thank you.
Thank you for your time.
All right, we will hear from the department.
Good afternoon, Lynn Murphy for the Department of Children and Families. I'll be splitting my time with the Counsel for the Child. Well, as this court knows, we have two preliminary issues to get through to even decide this case. First is the interlocutory issue that you asked for additional information on, and the fact that the grandmother did not appeal that as an interlocutory order. So at that point, her remedy was exhausted. And as she also admits, the issue is moot because the child has been adopted and there's no avenues
I don't understand the first point. I read the statute. I thought she has a right to appeal from the denial of her request to be granted visitation rights.
No, absolutely not. That's part of the only reason that grandmother, the underlying petition is the care and protection petition, not the grandparent visitation request. And if you look at 26B, it says, when the child is subject to a petition and placed in the custody of the department. That's the C&P petition. So this was ancillary to the C&P petition.
Why would party thereto refer to something not within that same sentence? And when we talk about a decision or the trial court is a party thereto, wouldn't we normally expect that the thereto is that decision or order?
Yeah, I think, are you referring to
Looking at 26B,
D?
Section D, yeah.
Right.
I mean, until your friend showed us that statute, I thought, oh, how could there be jurisdiction? But, I mean, there it is.
A grandparent may appeal an order of the trial court to the appeals court under this section if such person is a party thereto.
Right, she is not a party to the care and protection petition. That's the whole
But
problem.
it doesn't say that. It says order, a decision or order. A grandparent may appeal a decision or order. Why doesn't thereto refer to order?
Because it was filed within the care and protection petition. There was no separate petition number. There's no docket number difference. That is part of the care and protection petition. So she is not, she could have intervened. And as you can see, the problem when you don't have an intervention, she didn't know the child was adopted. The docket sheet was redacted. All of these things happened because she was not a party to the proceedings. And the clerk's office had to redact all that information because she is not a party. She does not get to have that private information when you're not a party. She could have intervened. There's other actions grandmother could have taken, but she did not do so. She is not a party, so she cannot appeal. She needed to do that through
But 26, so it says under this chapter, right? Or under this section. I mean, 26BA says, a grandparent of a child who is subject of a petition under this chapter and placed in the custody department may file a petition for visitation in the court.
Right.
That's what she did. So there's an
Right,
express grant of, if you will, a claim, a cause of action in 26BA. And then in the same thing, a grandparent may appeal a decision or order of the trial court under this section if such person or the department is a party thereto. Your position is she's not a party, even though she's explicitly referenced in 26BA as somebody who had the right to file the petition she filed.
The statute is giving you the process for where a grandparent can petition the court for visits, which happened here. But that does not give her party status. That does not confer
So her right
party
would
status.
be to go single justice then?
Yes, right.
And
As soon as there was a denial.
Commonwealth's position is the only way that this could be appealed is through single justice.
That is correct.
Okay.
Right.
So taking your other point, I understand that's not what's going on here, but doesn't a juvenile court judge have equitable discretion to order grandparent visitation even after adoption?
Yes, but that is a very different issue. Post-adoption visitation is controlled through the equity powers and the case law. That's a very exacting standard. And the whole problem with post-adoption visitation is there is an interference with the new family. So there's much case law on this through the SJC in many cases. It's a balancing. We're balancing constitutional rights of parents and constitutional right, which actually has been terminated, but then constitutional rights of the new parents. So a grandparent, well, quite frankly, if the parent as a party wanted to propose visitation with the grandparent as part of their plan, they certainly could have done so at the CMP level, and that could have been reviewed by the court, by the juvenile court. And then that could even be reviewed on appeal. But that has to come through the party. That has to come through the parent. And the judge would, in this case.
I don't follow that. The grandparent.
It's not a party.
Assuming that I don't think there's an SJC opinion on the rights of a grandparent to post-adoption visitation. But there is a case from our court that suggests that the grandparent has post-adoption visitation rights, potentially, that could be granted in equity.
Potentially.
They would have to file a claim in equity, right? I would like to visit my grandchild, and here's the reasons why. And are you telling me they couldn't do that?
Not as a non-party. I mean, certainly anybody.
It would be a party, because it would be their claim.
Right, but how would the judge order that without? They have to do it within the plan. So they have to look at the department's plan. When you're terminating parental rights, right, you have two pieces, unfitness, and we consider the plan at that time. Now, could visits with a grandparent be part of that plan proposed by somebody? Certainly, it would be more helpful if a party proposed that.
You're operating on a series of assumptions that I don't follow. Now, maybe that's because the case law is about parents' rights, and they are always parties to the proceeding that leads to the adoption,
That's
right?
That's correct.
Unless they've been terminated early, and if they've been terminated early, then we have a question of whether they even have standing when adoption occurs.
Well, usually if they had input at the plan, even when their rights are terminated, they can still, the SJC has made that clear, that they can still litigate that issue.
Do they get notice of the adoption? If they've been terminated early, do they get notice of the adoption when it occurs?
I'm not sure what you mean early, like before the
There's a-
trial ends?
There's a termination of parental rights, but there has not yet been an adoption because it wasn't ripe. There was nobody to do it.
Okay, so we didn't have identified a pre-adoption.
Right, exactly.
Okay,
So then
right.
a year later, when the adoption's going to take place, and there's some proceeding associated with the adoption, as I understand it,
Yep,
right?
yep.
And the department comes in and says, we're good with this, these are the right people. Do the parents get notice?
No.
That's after the appeal's over, right?
Yes, usually, unless there's, right,
So,
usually that
in
was
that
right. So
context,
they have
the parents couldn't, under the case law, bring a separate petition in equity for post-adoption visitation?
After their rights are terminated and they've moved on, no, absolutely not. They have to do that during the C&P trial. They need to propose that as part of the plan and put on evidence why that would be the court's social rule in the child's best interest. By the 210 here.
The problem here is the grandparent isn't even getting notice of the adoption. She
Right,
got
because
nothing.
she's not a party. She has no constitutional right. Her right, she has an important right, like a sibling has an important right, but that doesn't elevate her to a constitutional right, like a parent
Why does it
has.
have to be a constitutional right? She has a statutory right
But the
prior to.
statutory right is different than a parent. She is not, and that's exactly the flaw in the argument. She should get this presumption is the argument because she's the grandmother. She doesn't get the presumption because she doesn't have a constitutional right to that grandchild. That's the problem with that analysis. That doesn't mean that the court couldn't consider.
Now, the problem with that analysis is it ignores the statutory language. I
don't
don't
think
care
the
about
statutory language-
Well, pardon me. When we're talking about the right, we'll start with the statute, and we'll
Right.
try to figure out what the statute means. And that's the argument that's been made, nothing to do with the Constitution at all. The argument that's been made is, this gives me a presumption that I can visit before termination, and before adoption. It's very confusing to me, because Judge Ditkoff asked the question that was on my mind as well, which is if there are rights that the grandmother potentially could get through equity post-adoption, but there's no way to notify her of what's going on, and then you're saying, no, someone had to do it during the plan, but grandmother doesn't know about the plan.
Well, she did. She was at trial. When the hearing, she knew what was going on at that point. She didn't know after that the child was adopted, but the department plan was that was part of the hearing. But and I think this is the other piece that I would point out. The judge in this case, that's why he analogized to the sibling visitation cases. There is no presumption. Now, siblings also play an important role, not unlike a grandparent, but they do not have a presumption that visits are in their best interest, and the grandmother doesn't have a presumption either. That's the difference, and the statute does not establish such a presumption. And again, I would point, that's why the trial court.
What do you think about the argument? I'm sorry, one more question. I know the red light is flashing like crazy.
You can go as long as you want. I just want to make sure that she's still answering your question.
What do you? We haven't really addressed the argument that your opponent makes, which is that even though the case is moot and conceded to be moot, we should still address this legal question. What do you think of that?
I don't think you should because of the interlocutory nature and failure to do that in a timely manner, but that would be my argument, and obviously this court can find differently.
Do you think that there are any exceptions to mootness doctrine that apply in this context that would allow us to go forward?
Not that I am familiar with. There are no further questions. I'll rest on my brief. Thank you very much.
Thank you. We'll hear from the counsel for the child.
Good afternoon, Your Honors, and may it please the Court. Diane Messer-McGee on behalf of the child. To get to your point, Justice Englander, no, this Court should not be taking up this issue. It is not capable of repetition, yet evading review. First of all, we have to ask ourselves, what's evading review? But let's go to the Supreme Court of the United States standard as to what constitutes evading review. And I'll refer the Court to the case of DeFunis versus Odegaard, which was about a Michigan law student who was claiming constitutional discrimination for not being allowed entry into law school. But the law school let him take it pending the appeal. He went through school, the appeal took a long time. By the time the appeal got to the court, he had graduated. And so the question was, should they take up this discrimination case, this racial discrimination case, because it's capable of repetition yet evading review? The court said no. And the court said no, and I'll read the court's holding with regard to it. It contrasts, this DeFunis case is contrasted to Roe v. Wade, which was the first time we saw this capable of repetition yet evading review, where pregnancy is of a particular time, and Jane Doe had the baby during the pendency of the appeal. This is not that case, and the present case before this court is not that case either. So the court just says, by contrast, capable of repetition yet evading review, where DeFunis claimed that the law school violated his constitutional right. Unlike the challenger to the abortion statute, who could very well have become pregnant again in the future, the petitioner in DeFunis would never again be required to run the gauntlet of the law school's admission process once he received his Juris Doctorate.
Counselor, the problem is, I like that rule, but it's an Article 3 rule, and the SJC doesn't seem to follow it at all here, and we're not in Article 3 land, and doesn't require it to be capable of repetition by the same person.
Understood, Justice Ditkoff. That still doesn't change the problem that this court has. So you may have another grandparent come forward with the same visitation. And I think the confusion here is we're equating the phrase yet evading review with the ultimate adoption of a child. They're not the same. So yes, this situation is going to come up again. The child is going to, if the parents' rights are terminated, be adopted. And then pursuant to certain statutory limitations, grandparent doesn't have the right.
Well, let me ask you this. It seemed, as your friend was suggesting, that this one sure took a while. I mean, normally it takes a lot longer to get to termination. Obviously, when both parents are in prison, you know, for life, it's going to go quicker, but
Right.
that's not normally the case. Usually a much longer lead up to termination, and then usually some lead time from there to adoption. So I guess we're trying to figure out how likely it is that a grandparent would be able to get through the appellate process before you got to ultimate adoption. This case doesn't really tell us that because it's such a weird one.
And so,
So I'd like you practice in this area. I like your sense on that.
So my sense on that is that while, yes, these petitions take time, and this one took an exceptional length of time, the court still has to answer the question, what are you going to be doing with regard to issuing an opinion? How is what you're going to write from this case not an advisory opinion based on hypothetical facts? That's that in the issue, in the interest of judicial restraint, the courts don't favor that. And I don't see an exceptional circumstance, which is what the exception capable of repetition yet evading review mandates, some exceptional circumstance that puts this particular case in one that not just is going to have grandparents come.
An issue that the juvenile court judges are talking about and are concerned about, who has the burden in this context?
I don't think that's I think it's a somewhat disingenuous problem, because I agree with Your Honor with regard to the burden of proof, the burden of production. But in the end, the juvenile court judge did not adopt a stricter burden of proof in this case.
Did announce it. I think.
Yes.
And I think that there's a fair comment from your opponent when somebody says, well, the burden's on you and it's clear and convincing. That could affect your trial strategy. So maybe it would be helpful for people to know what the rule is. And that's why I asked the question. You know, the case is moot. So if we're going to do this, it would be because we think it's important and it's capable of repeating itself, and it's something that people would like direction on. There is a case about mootness that I wrote involving the use of Zoom hearings by DCF, where we talked about some of these issues, and we said we're going to go forward and tell people, you know, whether this is right or not, and what the rules are. So anyway, that's, I'm not even sure there's a question in there.
Well, I take it as a question in that, do you think that it is persuasive to me that the somewhat.
Courts need direction on this.
If I suggest that the court issued two burdens here, whether it was clear and convincing and fair preponderance of the evidence, is it significant enough? Is it exceptional enough for this court to render a decision outside the mootness of this case? That's the question before the court. Can you clear that procedural hurdle? Child's position is no, because let's go back to what these cases really are about, the best interest of the child. Okay, and whether or not this child appears in court or has to hear from another attorney, whom every time this highly traumatized child has to see will think that he is going to be taken away again and trigger all sorts of problems. In the interest of justice, are we weighing the benefit of a decision that's nuanced when it's set out already? We know what the standard is. Right, the standard is articulated. The question is, did the trial justice, did the juvenile court commit clear error of law in his decision? When you read the decision as a whole, I don't think it justifies this court taking it up. There may be another circumstance in which this court could and should, but I think in this case, the benefit does not outweigh the burden. And I think that this court, the hurdle in this case is high. And while I think it's helpful, I don't think, well, it's unnecessary, it's not been requested. There have been no challenges to due process here. Grandmother didn't raise any questions that she didn't have a fair opportunity to be heard. Are they entitled to notice of the adoption? No, they're not entitled to the adoption. With regard to the statute that controls, I just would like to make one point relative to my friend DCF's position on Chapter 118. So we rely on Chapter 26B, A through D, for the reasons Justice Englander articulated, as it is an all-encompassing statute. It does, paragraph D refers back to paragraph A, and in fact, that grandmother was a party there. Our position is that arguably, assuming that she had statutory standing to bring her appeal, it still should not be heard. She's conceded mootness. There's no question of abuse of discretion. It's just whether or not that this case, on its facts, and going against what the child believes is in his best interest, would warrant this court lingering and, as the court has said, persisting in this tortuous path for this child to get to his forever family.
All right. Thank you, Counselor.
Thank you. If there's nothing else, we rest on our brief and our memo. Thank you.
All right. Thank you both. We'll take this under advisement. I'd like to thank our clerk. I'd like to thank our court officer and our timekeeper and all the attorneys that appeared in front of us. It's always very helpful to have these oral arguments. And with that, court will be adjourned until tomorrow at 9:30 a.m.